Open the hearing on House Bill 285 on parental rights and responsibilities. An additional section is we're asked for by the prime sponsor, who is not here.
Oh, yes. You made it.
Is here. Wow. So when you're done blowing your nose, please come on down.
Good morning, Chairman Pearson and the Children and Family Law Committee. Please pardon my appearance. It was really windy walking here, and I do not have a hairbrush with me.
Some of us don't need a
So
hairbrush. We're
you
jealous.
are so lucky.
Okay.
For the
You
record,
are
you
so
look
lucky.
great.
I come forward to ask you to consider House Bill 285. It's on the surface a simple clarification. It's not even a clarification. It just adds words to remind judges to make sure that they're looking at a full environment for children. And it asks judges to look at, as another factor, any known mental health conditions that could interfere with parenting. In no way am I advocating for judges to ask for private information or to disclose counseling or to give over medical records. However, for a judge to truly make a determination in the best interest of the child, they need to understand the full ecology and environment of the home situation. As we know, or many of us know, divorce is one of the biggest stressors that a person can have in their lifetime. And that includes the custody determinations. It includes changes often of employment, households. I mean, these are the biggest stressors that we face as adults. When you look at that, and then you compound that with one or both of the parents having a known mental health or even a medical condition that could be aggravated by this stressor, the judge needs to be made aware of that. And again, not looking to take children from parents. I'm looking to assure that the children have a safe, healthy environment to go to. When parents are married, they are very fortunate that they have each other to pick up the slack if one is not feeling well or one is having any kind of a mental or a medical crisis. They have a support system. But after the divorce, these systems can fall apart, especially if the divorce is not amicable. Then we're sending home children to home environments that may not be in their best interest. These are young children now who have to navigate a home environment sometimes by acting like the other parent and helping the parent they're with at that time to be able to function. Again, I cannot stress enough, I am not looking for private information. I am not saying the judge, I would hope our judges would be well informed not to ask for any personal information from the parents, but simply ask a question. Is there anything that I should know when I make a determination on parenting? And that could be as simple as, and this might not be the right thing to say, but I'll say it. It could be as simple as understanding that the parent needs to continue in counseling or needs to be on medication or needs, and that is up to the parent to, if they want to provide that. But the judge needs to know this in order to assure the safety of the child. And I'm open to taking questions. I'm sorry, I'm running here so late, and so I'm a little discombobulated.
Well, we hope you will be combobulated.
Thank you.
I think so. Would you believe that in almost 50 years of being a clergy member, I've had numbers of families where there were mental health issues, but that did not necessarily impact their ability to parent well, that I would put there being somewhat of a spectrum of ability and inability, mental health issues by themselves not being a determinative, would you believe?
I would absolutely believe that and agree with that. I think that this, what we're adding in, would be adding into this bill would just provide the opportunity for a judge to ask a question. No more than that. I certainly know of many people who may have challenges, medical, physical, emotional challenges, who are very good parents. And I'm not trying to sit here and say that just because you have challenges in your life doesn't mean you can't parent. But if those challenges do interfere, then we need to have a mechanism to make sure that the judge knows that, and so that he can make an appropriate decision as far as the best interests of the child.
And would you further believe that since this, as you describe it, is simply a reminder, the extremely well-crafted amendment that I have in my hand spells that out exactly, to say that medical or mental health condition that could adversely affect a person's ability to parent is a yet further reminder to a judge what he or she already knows?
I would definitely agree with that.
Any other questions? Representative Raymond.
Thank you, Mr. Chairman, and thank you, Representative Ball, for coming back to our committee. So my question is about the whole passage that you're quoting, 461A6, has A through M. And so A is that the judge has to consider, I'm sorry, B and C. A says that the judge has to consider the ability of each parent to provide the child with nurture, love, affection, and guidance. And B is the ability of each parent to ensure that the child receives adequate food, clothing, shelter, medical care, and a safe environment. And so my question is, why wouldn't that the prescriptions that the judge already consider the parent's ability to provide these things for the children not cause the judge to look at things that would interfere with their ability? Like, I guess I'm confused about how this language increases the focus on the best interest of the child as opposed to looking for reasons why a parent wouldn't be able to parent.
Thank you for your question. I believe that many of us are aware of the revolving door in family court with the judges. And even though we are supposed to have one family, one judge, it doesn't happen. And there are people that have certain mental illnesses who can present themselves as very thoughtful, caring parents. They can present that once. But then when they come back to the court the next time and the next time and the next time, the judge starts seeing a pattern of behavior that indicates there could be a mental health issue happening here. But since we don't always have the same judge, a judge is not aware of that, and a person wouldn't present that way. And the other parent is not allowed to present any evidence in court. And so therefore, how do you get this information to the judge unless the judge can actually ask the question?
Follow up.
Thank you, Mr. Chairman. So what about those parents who clearly have mental health issues but have chosen not to seek mental health counseling or a diagnosis for themselves? How does a judge determine that based on this language?
Well, it's my understanding that the judge can order psychological evaluations if he sees fit. But this would open the door for him to ask the question and determine whether or not something should be looked at more closely. I think it also opens the door for the other parent to provide testimony and evidence that may indicate that the parent may have lapses in their ability to parent their child. Again, not meaning that that parent should not have custody of that child, but just that there may need to be guardrails put into place to assure that that parent is seeking the help that they need in order to be the best parent they can be.
Representative Gregg.
Thank you, Mr. Chairman. I was wondering if I was going to get called on there for a second. And thank you. And I will echo the sentiments from our other colleague. It's nice to see you back in here again. My question is, understanding the weaponization in these high conflict cases of stuff like mental health and, how that works. How is this to be known? Because there are a lot of accusations in high conflict cases of, even in abuse cases of, oh, well, this person isn't unfit, or they're unfit because maybe they were depressed while going through that or whatever else. But I just am confused as to what the basis is on how it would be known, understanding that becomes very weaponized in court.
Thank you for your question. And it's interesting that you bring up the weaponization within family court, because that is one of the biggest challenges in family court. And it happens before family court when systems are weaponized, like making false allegations against another parent. And those allegations can often be made by the parent who actually has the mental health challenge. And so they're not looking to look for the best interest of their child. They're looking to win at all costs. That is part of their mental health disorder or challenge. Saying that this would weaponize it, I think it actually takes that weapon away from weaponizing it within the family court, because you can't weaponize something if it doesn't exist. And if the person, you have to look at the whole dynamic. And I think by asking the question is what disarms both parents from weaponizing the family court, because it is now put right out there. We can't hide behind anything. We can't make false allegations. We can't just do things in family court to try and get the result that we want. And I think that this helps the judge determine where the truth is in determining where the best interest of the child lies.
Follow up.
And is there something right now that is keeping the judge from being able to weigh on this at all?
Well, when I spoke to Representative Lynn, when I wrote this up, and he was a Superior Court judge, higher Supreme Court judge.
Chief.
So I did run this by him, and his response to me was, there is no problem with a judge asking a question. My concern is that I would like to see that there, because my experiences and hearing from my constituents is the judges do not ask the question. That is never put out there. There is never an opportunity to share the whole home environment with the judge. As I said, in family court, you can't provide any evidence. So even if the other parent has evidence that this parent may not, I love my ex, like my soon-to-be ex, I love that person, but the person may not have the wherewithal by themselves to be able to parent in the best possible manner, in the best interest of the child. And I'm not looking to keep my child from them, but I need to be assured that that parent is going to get what they need to help them be the best possible parent. That's what I'm hoping this will do, is allow the judge to maneuver his way through this web and determine what is in the best interest of the children and how do we best meet the parents of both parents. As you know, I was a huge advocate for approximately equal parenting time. So I am no way am looking to lessen the amount of time a child spends with a parent. What I am looking to do is provide a mechanism for judges to have the guardrails put in place to assure that the determinations are always in the best interest of the child.
Representative Love.
Thank you, Mr. Chairman. Thank you for taking my question. You mentioned that, the revolving judge thing, and I think it's got a lot to do with burnout myself. These are tough cases, and they must have a tough time. But anyway, in your bill here, do you think it might be advantageous to amend it to have direct instruction for the judge to ask these questions?
Well, I think, thank you for the question. I think just putting the reminder there to the judge that is another factor that they should consider. I don't think they have to be directed to do it if they don't. I trust our judges to do what is right and to ask the questions that are appropriate. This would only serve as a reminder that we are looking at the whole picture and not just these little parts of the picture.
Thank you.
Representative Schur.
Thank you, Mr. Chair, and thank you for your what you've said so far. I'm a little, I think I'm beginning to understand, but is it my understanding that judges could ask questions about known mental health conditions now, but they don't? Is that what you're saying?
Well, thank you for the question. My experience from watching the family court and from the input that I'm receiving from my constituents is that the judges do not ask, and there is no opportunity for them to present any evidence that a parent may need to have some guidelines or guardrails put into the parenting plan to assure that that parent continues to receive the adequate or the necessary care to parent effectively.
Follow up.
Thank you. I'm not very familiar with family court, but isn't it the case that one of the parties, if they so choose, could say, I'm concerned about my child spending so much time with this parent who I believe has a mental illness? Can't they already say that?
Thank you for the
Not the child,
question.
the other
parent. My experience has been that although that is supposed to be taken into consideration, the parent cannot bring it up because then they would be presenting evidence again. And they would have to show. They can't just make an allegation in the court. And even if they had the evidence, they can't provide it unless the other parent is on the stand and opens the door for that evidence to come in. For instance, we went last year and we watched many cases, and then my constituents, as I said, and from what I'm hearing is that unless the parent on the stand brings something up, the question can't be made. So if a parent was to bring up, I don't know, I'll just give a for instance, they happen to mention Facebook. Well, that's an opportunity for the other lawyer to say, oh, you mentioned Facebook. Geez, have you seen what's posted on Facebook? And that's how you open it. But that lawyer could not just say, did you post these on Facebook? They have to wait for the door to be opened in order to get that information in. That's has been my understanding. That's what I'm hearing from many constituents. And that I'm just pulling that out of the top of my head. But does that answer your question? I'm sorry.
Close enough. I think I'm
Okay. I do.
I don't know enough about family
Okay.
court to be
Well,
able to
let me remind you or fill you in on what we found out last year or the last two terms. 80% of the parents that are in family court are pro se. So they don't have the wherewithal to know how to get this information to the judge. And so the judge needs to kind of steer the case and the court into the direction to make sure he gets all the information he needs to make an absolute educated best decision for the best interest of the child. And for those other 20%, those are typically, I won't say typically because maybe that's not the case, but they have attorneys who know how to maneuver the family court and know how to get evidence in and know how to get this information before the judge. My concern is on those other 80%, and maybe they might be the 80% that don't matter. Maybe it's just the 20% of high volatile cases that really need to have this brought forward. But we never seem to be able to get it there. And that's what I'm trying to make sure that the judge actually has something in writing that says, I'm allowed to ask this question. I'm not going to ask you for any of your medical records. I'm not going to ask you for your counseling records. All I want to know, is there anything I should be aware of that might interfere with your ability to parent?
Thank you.
Representative George.
Thank you, Mrs. Chair. Thank you for your concern. I'm not just like ask a question, but I think so you're doing something that's very good for kids. I've been there and I understand everything what you say to understand for parents to be for the ability, especially for the mental health.
Thank you. Anyone else? Final question? Representative McMahon.
Thank you, Mr. Chairman, and thank you for taking the question, Representative Ball. To add on a previous comment from one of the members relative to the judge asking this question, in the narrative when it states if the court deems relevant, well, de facto, the judge could deem it not relevant even before it's even brought up. In my interpretation of that, should language not be where it is a requirement, for lack of a better word, that the judge would ask for this type of information, and knowing that evidence apparently can't be accepted unless it's the context is offered within a narrative.
Thank you for asking that question. I will mention that there are several other states that already have this in their law, that it is required for the judge to take this into consideration and to ask the question. I think the point of then the judge, if the judge has that information, then they can deem whether or not it's relevant. Is it going to interfere with the parent's ability to parent? But they can't make that determination if they don't have the information to begin with.
Just follow up.
Follow up.
Thank you, Mr. Chairman. Just to follow up on this, then, it would be the representation outside of a pro se, but a representation of the petitioner that this information would be then provided, which would then have the judge responding to it. That'd be the only other alternative, because the judge could duly now just say it's not relevant if that doesn't come up in court to begin with.
Well, that's an interesting question. Thank you, because it does bring up the point, and as I'm thinking, and I thought about it this morning, of mandated reporting. If the judge asks the question, are the parents then not mandated to report whether or not they have seen situations where the child was not being parented correctly or in the best interest of the child? So this would be something that would have to open the door and get that information to the judge. Am I understanding your question correctly?
Well, it's a debating point.
Okay.
Right now, just to follow up on one of them is the term relevant transfers the responsibility then specifically to the judge to decide whether it's relevant or not, unless it's in the narrative to state you shall as opposed to may ask for this information, and to follow your guidance. The ultimate authority here is the safety of the children and possibly the other adult as well. So that's why I was wondering whether the relevancy would require an additional sentence to state you shall ask on this subject, or there could be others added to it.
I appreciate your question. When I wrote this, it was to try and keep it in a simple, it started with just other factors to include. And so it's just one of those things to just throw out the reminder that there is more than just looking at what's on the surface. We need to look at what's underneath the surface as well. That was the intent when I wrote it. If it would need to be amended, I would be more than happy to work with the committee on an amendment, or the committee can amend it as they see fit.
Okay. Thank you, Representative Ball. Thank you, Mr. Chairman.
Anything else? Any other questions? Thank you for your testimony.
Thank you, Chairman Pearson, and thank you to the entire committee. I appreciate your time in considering this bill. Thank you.
The chair recognizes Sarah Horn. Ooh, I was watching Boston sports last night. I apologize. Sarah Horn, who wants to speak for 3 minutes and has some handouts.
Good morning, Chairman Pearson and committee members. Thank you so much for the opportunity to testify today. My name is Sarah Horn. I am a NAMI New Hampshire board member and In Our Own Voice presenter. I live in Manchester. However, I'm not testifying in my capacity as NAMI today. I'm testifying as a resident and parent. I'm here today to speak in opposition of Bill 285. So at a young age, I was diagnosed with obsessive compulsive disorder. By the time I turned age 13, this disorder significantly impacted my ability to function in my daily living skills. Getting out of bed every morning was extremely daunting. I knew that I would be living in fear all day, constantly completing rituals to try to minimize that fear. I couldn't see that it could get any better. And at the age of 13, I came home from school and I tried to take my own life. For the next 4 years of my adolescence, I had 6 hospitalizations and a residential placement. In addition to OCD, I also live with attention deficit disorder and post-traumatic stress disorder. I was extremely fortunate that I had supportive parents that stopped at no end to help me get the resources that I needed to have a successful recovery. I share this with you today because I'm a senior HR business partner at a local nonprofit, and I've held this position for 19 years. I serve on 2 boards in the community, and the role that I am most proud of is that I am a mom to a 3-year-old boy. I am proof that recovery is possible, and that my history of mental illness has no bearing on my ability to parent. If anything, because of my experiences, I am more patient, empathetic, resilient in my parenting, and I hope that I pass all of those traits on to my son. I know what I need to do to keep myself well, and I am actively focused on that. My concerns are that this bill will allow for further discrimination and damaging stigma. I could only imagine how difficult and emotional a parental rights custody hearing could be for somebody. And my concern is that if this bill should pass, it would deter people from seeking the mental health counseling or support that they need to keep themselves well. I ask that instead you focus on active and current behaviors of the parents, not a health history, because we are not our diagnosis. For these reasons, I respectfully ask the committee to vote opposed to House Bill 285. Thank you so much.
Thank you for your testimony. Would you believe it is this kind of testimony that prompted me to file the amendment, so that if the amendment passes, the bill would read not only mental health, but physical health as well, so that the spotlight isn't on one thing, and that could adversely affect a person's ability to parent. It sounds like you're a victor, and your history does, if anything, informs your parenting,
Right.
but it does not hurt it.
Correct.
So with the additional language of the amendment, would you believe that would take away some, if not all, of the stigma?
No, because I think that a health history, how long ago could this be, right? And I think that any of that could have no impact on your ability to parent. I think when we take into consideration health and mental health, I think we need to focus more on what are the current and active behaviors of that, not what has happened in the past or what is on a label.
Would you consider that a condition today?
I'm sorry?
Would you consider the past difficulty you mentioned a condition now?
Yes, it's an active diagnosis that I'm very upfront about, and making sure that I'm keeping myself well. I'm always in active treatment because I think that's what you need to do to continue to keep yourself well. So the fact that if I were to ever be in this situation, for them to take into consideration that I was actively seeking supports that continue to keep myself well in my recovery, and that could be held against me, that's concerning.
Any further questions? Thank you for your testimony.
Thank you so much.
Chair recognizes Kevin Blanchette, who asks to speak for 2 minutes. I'll give you 3.
Hello, thank you, representatives. I've also provided written testimony online as well, but it was a little bit longer, and I wanted to respect your time today. So my name is Kevin Blanchette. I'm a licensed clinical mental health counselor here in the state of New Hampshire. I'm speaking today to oppose this bill. While I appreciate the concern we have for our children in reading the current language of the law, I believe that it fully represents the care of the children. It considers factors of the school system that your child is in, and if they'd have to move to school systems, the care the child has the ability to receive from each parent. It considers abuse, potential abuse towards the child or towards the parents. These are things that we are concerned about. Adding mental health to this list just stigmatizes mental health and presumes somebody having a mental health condition makes them lesser of a parent. It means that there's things that they cannot provide as a parent because of their own mental health struggles. I had looked this up last night, and a report from the state in 2023 said that a quarter of people living in New Hampshire have a mental health illness. I believe that is to be a larger portion of the population because a lot of people do not come for treatment. And by not going to treatment, you are not going to receive a diagnosis. You're not going to be considered having a mental health illness, even though if you went to treatment, you maybe would then be considered. That gives reason, this bill would give reason for people to not seek treatment out of fear of how it could be used against them if they had a mental health illness. I'm concerned with that impact. As a mental health counselor, I can tell you I frequently write letters to the court for people, letting them know that this person is in treatment. So I am frequently asked these questions and asked to represent this, and this is frequently coming up in court for people when it is a consideration. As the law has it now, if it is something to be considered, the judge is able to ask for it. I recognize that maybe the judges are not always asking for that, but then we should really be considering, how much of a consideration is that, or is it more the behaviors that are being discussed already in court that are the consideration, not the mental health? I thank you for your time.
Would those with a medical condition similarly not seek treatment lest this become discovered and therefore not seek treatment because of that?
I cannot really speak to that as I only see people for mental health and not for medical conditions.
Very good answer. Any other questions? Representative Love.
Thank you, Mr. Chairman. Thank you for taking my question. Wouldn't HIPAA cover a lot of this? If someone comes for mental health help, the HIPAA does certainly, keep it private.
Yes, so if HIPAA is in place, it does keep privacy. A judge can change that. They can subpoena records. They can subpoena and they have the clinician come and speak if they choose so. That provides a lot of stress and planning on us as clinicians, as we need to get lawyers involved, and not all clinicians will be doing that to the best of their abilities. Some clinicians will still have questions. They may, there's a lot of legal concerns that we have, and how much do we share, how much do we not, what can we redact or block out for the records being brought to court. And there can be some intimidation towards us of courts really want everything. We want to try to limit that, and confusion, questions come up from that. It's not cut and dry. Again, if the judge asks for this, they currently can ask for this. This would just make it that the judge is more likely to be asking for more information, and presuming mental health is a negative thing that can impact their parenting.
Representative George.
Thank you for coming to testify. I just want to know, do you know there is the people from mental health who are deniable? You know that there is they know they have a problem, but they don't accept.
Yes, there's many reasons for people. Sometimes it is due to concerns that may come up if they do accept it. Sometimes there's what's called anosognosia, which is a symptom of some mental health illnesses where a person does not have the ability to recognize their symptoms. Even when they are explained to the person, their brain is not able to process it. They don't recognize it.
Follow-up. Thank you, Mr. Chairman. When I talk about deniable, because there is I know a couple who was very the man is with a mental health already everything, but in the court, he said the wife who are mental health, and then the court believe the guy, the man, and then the wife who's not never be in
Make it
mental
a question, please.
health. That's what I want to say for the deniable. do you believe like those people can just make somebody else a problem?
So my concern is that they would be making somebody else a problem, and then now this person's mental health is being considered. When we're bringing mental health in, there can be a big blame game. There can be a lot of pointing fingers. We should not be looking at a person's mental health, but their parenting, their actions, behaviors, things that have happened, which I believe the law as it is currently written does do. Thank you.
Anyone else? Seeing none, thank you for your testimony. Chair recognizes Attorney Holly Stevens from NAMI.
Chairman Pearson, members of the committee, thank you for the opportunity to testify this morning. My name is Holly Stevens. I'm the Director of Public Policy for NAMI New Hampshire, the National Alliance on Mental Illness. I'm here today to speak in opposition to House Bill 285. As you have read, House Bill 285 allows the court to consider, quote, any known mental health conditions of the parent, and that is how it's written. It's not the amendment. I understand there is an amendment. As a factor relevant to the determination of parental rights and responsibilities, regardless of that condition's impact on the person's ability to parent. This only furthers damaging stigma and jeopardizes the rights of individuals living with mental health conditions. Simply having a mental illness, like simply having a other health condition, in and of itself does not inherently impact a person's ability to parent their child. While one's symptoms relating to their condition may progress to a point that impacts the parenting ability, that is not unique to mental illness. If a parent has untreated epilepsy or diabetes, they could have a period where they go unconscious and are unable to care for their child. There could be other medical conditions as well that impair their ability to parent if left untreated. However, this bill makes no consideration for any health conditions other than mental health conditions. From NAMI New Hampshire's perspective, targeting a specific population of individuals with mental illness without any consideration of the condition's impact on the parenting ability, rather than considering all health conditions, makes this policy discriminatory. With treatment and support, people are able to live full, successful lives, as you heard Sarah Horn talk about. Just the same, someone with a chronic health condition can live a full and healthy life. Simply put, no one should be singled out because of their diagnosis. Beyond being discriminatory, this policy is also unnecessary. You heard the previous speaker talk about the fact that all of these factors can be considered already under the law. It's not necessary to call out mental illness in and of itself. It is really looking at the parents' behaviors and their ability to parent the child. Additionally, if there are immediate concerns about a parent's ability to parent, then you can call DCYF. That's what they're there for. If a parent's symptoms start interfering with their ability to parent their child, you can pick up the phone and call DCYF. And parenting plans take a long time to establish. And so using the parenting plan as a way to save a child from a parent's potential mental health conditions affecting their ability to parent is not the best way to go about this. I did include some language that NAMI New Hampshire was okay with if the committee would like to pass a bill, which says, including due consideration for any known health conditions that impact the best interest of the child. I know that the amendment says health conditions, including mental health. That is something we would still oppose because it specifically calls out mental health and shines a light on mental health, which we do believe is still discriminatory. So for those reasons, we are opposing this bill today, and we would oppose the amendment as I heard the language that Chairman Pearson spoke.
Are you familiar with the fact that in other contexts, mental health is asked to be referenced because the assertion is otherwise it is forgotten, and mental and health conditions is assumed to be physical? So would you believe that? I mean, is that in your experience?
I think that one of the things that we're trying to do is educate people so that isn't the experience. I mean, health conditions contain mental health conditions, and it should be that way. And maybe we need to educate our judges, not change our laws. Because if it's an issue with the judges not asking the questions, then that's an education issue.
Well, as you know, I've been fighting for continuing education for judges for some time, and will continue, especially as long as my wife has to do beaucoup amounts as a physician. So I'm with you on that. Let's do that. Any questions for the counselor? Representative Scher.
In interest of full transparency, Ms. Stevens suffers from the misfortune of having had classes from me while at the law school. So I just want to make that clear up front.
Are you recusing yourself or recusing her?
No answer to that question. So is it,
You're welcome.
there's the
No,
Fifth Amendment thing.
Thank you.
Maybe you haven't
Mr.
gotten that.
Chairman. And then,
Thank you, Mr. Chair.
you're welcome. Now,
And thank you, Ms. Stevens. Is it NAMI's position that just the name of a mental illness, saying that somebody suffers from X mental illness, tells you nothing about the quality of their parenting or their ability to provide fit parenting?
That is correct. Even folks who may choose not to get treatment, it doesn't mean that their mental illness has any impact on their ability to parent. You really need to look at their behaviors, not their diagnosis, and that is our position.
Thank you.
any further questions? You are so backlighted. It's just sort of wave. You are the new Representative Raymond this term. Representative Levesque.
Thank you, Mr. Chair, and thank you for taking my question. Do you believe that as a society today that there's like this stigma around mental illness that we have, that it's seen as kind of a definitive, like that defines you versus it's a part of you and it's not what defines you?
Yes, thank you for the question. Yes, we do believe that. I mean, one of the things that NAMI New Hampshire strives for is to rid our society of stigma and discrimination against people with mental illness. And one way that we do that is by fighting against bills such as this.
Seeing no further hands, thank you so much.
Thank you.
Chair recognizes Karen Rosenberg, not to be confused with Rosenberger, which I do constantly. And you're a lawyer, correct? Are you one of his students?
No.
Okay, you may continue.
Thank you. Good morning, Chairman Pearson, members of the committee. I'm Karen Rosenberg. I'm the policy director at the Disability Rights Center, which is New Hampshire's protection and advocacy system for people with disabilities. I'm here to testify in opposition to this bill for the reasons that you've heard from, I think, uniformly from everyone, with the exception of the bill sponsor, of course. We see this as very discriminatory and furthering the stigma of mental illness. As you've heard, just because someone may have experienced a mental illness, either currently or at some point in their history, doesn't mean that they are not good parents or that they cannot be effective good parents. And so enacting a law that would single this not even a particular condition, but just the fact that someone has experienced some mental health condition at some time, we see as perpetuating discrimination, perpetuating a stigma, and really not necessary. Our current law provides a list of factors that courts must consider when they're determining whether enabling a parent to spend whatever amount of time they decide they're going to spend with their child is in the best interest of the child or not. And besides having this list of factors, which is, quite broad, relationships with the child, ability of each child to parent, to provide nurturing love, affection, and guidance. I mean, you've gone through the list. You've heard from other people. There's also broad discretion for the court to consider any other factor. And courts do ask unrepresented parties questions. I have not practiced in family law court since a clinic in law school, but in my experience practicing law, when courts have questions, they know how to ask them. And if there are concerns that are raised, courts can inquire of the parties whether there are concerns about parenting. And I think that a parent who is concerned that the co-parent is potentially going to be harmful in their parenting approach to the child, they will be able to raise that and the court will be able to ask questions under our current law. And it's just not necessary and potentially harmful to single out mental illness or really any physical illness too, because people manage both physical illness and mental illness all the time, and it doesn't necessarily impact their parenting abilities.
Any questions for the witness? Representative Love.
Thank you, Mr. Chairman. Thank you for taking my question. Having gone through a thing like this and, not being able to bring up mental illness, I've got a 25-year-old that's still in therapy today. It's a generational thing. When bad things happen to kids, they tend to stay a mess. Would you have any suggestions for and I do believe in recovery from mental illness, by the way. Okay. Do you have any suggestions that you could give us to amend this? We've got this one here, just take the mental part out of it and just health questions. But something needs to be done because the courts are ignoring the law.
Well, that may be, if courts are ignoring their obligation to make rulings and ask questions to determine whether a particular outcome is in the best interest of the child, that's a whole other problem. Right? Our courts really are in place. We nominate judges and go through a process, and there are evaluations of judges after they've been in office. I mean, that's a different kind of problem. You could pass any number of laws, and if a court is not following the law, that's a whole other problem. I think the current law is not the problem. I think the current law gives courts what they need to make inquiries to determine whether a particular placement decision or parental responsibility decision is in the best interest of the child.
Would you second Attorney Stevens' statement that perhaps in the, we hope, ever-growing amount of excuse me, ed the judges have, there'd be a little section on this?
Well, certainly it would be helpful for courts to be, have opportunities to be educated around what are the factors that they need to consider when making these really very important decisions that will impact the life of a child.
Thank you. Any further questions? Representative Kozer.
Thank you, Mr. Chair, and thank you for being here to answer our questions. I'm just wondering, you may not even have the answer. I may have to ask DCYF this, but how many children are in DCYF custody or have been, placed on the adoptive track, actually have parents with mental illness?
You're correct. I don't have that
That's okay.
information. Sorry.
Anyone else? Okay, thank you for your testimony.
Thank you.
Chair recognizes former State Representative Betty Gay. This closes the hearing. You have been called. I have a pink card. Okay. I have called you to come up. I'm reading your card.
Thank you for allowing me to address you with my feelings about this bill. First of all, to me, a child's needs trump a parent's needs. Hopefully, we want to be fair to both, but the child is more vulnerable. This bill is to address any known active, current mental health conditions of a parent that are affecting their parenting. This bill is not interested in a parent's mental health history. That is not necessary. Accommodation of the illness can be made to continue parenting as long as we're concerned that the parent, we are concerned that the parenting is healthy, and a person with mental illness who's being treated and feels good, that person is not a target of the changes that we want to be made. The majority of states in the U.S. have laws that specify consideration of current mental health, not the history of the health. Currently, New Hampshire law does not allow such consideration, and this certainly cannot be initiated by the other parent. They are prohibited from bringing the issue up. I would like this bill to be amended to address the concerns that you're bringing up. But the bottom line is the issue has to be brought up in the consideration for parenting. Any parenting should be considered that's considered wanting should be observable by other people. If they're really good, if a parent is really vindictive and really unusual, they can hide it from other people. But usually other people are aware and are concerned for the child when they observe negative parenting. Some people are really good at hiding it, but I'd say that people in court are generally going to believe other people more so than the other parent. So it's really helpful if other people are willing to stand up for that child and testify on what they've observed. But they also have to be permitted by the judge, because that can be denied under our current rules of family court. The presiding magistrate, I don't use the term judge easily because that's a definition, and we don't have that kind of judges in family court. So I'll say magistrate. The magistrate can choose not to have any testimony, not to have any evidence shown. So what we're asking for is that this would be a requirement that they look at other input if there is a desire to do so. Okay, so that was my point number 5. Right now, we cannot discuss that in court unless by a little slip of the tongue by the other person to open the door, but only a person with a really good attorney would notice that. So my conclusion is, please craft a bill, totally rewrite it, that will protect children from being raised by a parent who consistently puts the child down with constant criticism. That's a really hard subject to address, and it is a very real issue that we don't have adequate wording. We don't have adequate wording to address right now.
May I ask you the question of where in the law is the things prohibited that you say were prohibited? So I can go look it up.
I can know. Well, I wish I knew that. It's kind of hard to find things that are missing.
It would strengthen your testimony when you say the law prohibits if you tell us where to look it up.
all I know is from practice, from people who've been through court who are not permitted, who have not been permitted to bring it up. And certainly I can ask questions and see if I can find which RSA subparagraph delineates that.
That would be very helpful. So what you are saying, if I get you correctly, is the reason it is not being brought up is in the family division, the rules of evidence are discretionary to the one presiding at the hearing. Is that your testimony?
That is true.
Okay.
The other part of your question, I don't know. If they did choose to allow the testimony, where would the prohibition be? All I know is in actual practice of the law is not permitted.
Thank you. Any other questions for the former representative? Seeing none, thank you, and we'll look forward to your research. We will be execing this bill. It's been advertised 2 weeks from today. This closes the hearing on House Bill 285, and we will exec it in 2 weeks. Now I'd like to open the hearing on House Bill 177. And oh wow, she even changes the sign for us. Do you take coffee orders or Girl Scout cookie orders or anything?
Not if you expect them to be
No.
correct.
For
Okay.
the record, Mr. Chair, she doesn't change the sign in House Criminal Justice. She never does.
She's the away team counselor. And Representative Ball. Whoops, we need a pink, not unlike the pink card you're already filling out. Thank you. And we've got some stuff being handed around here, I think. And we're going to need one for the vice chair and pretty cards and thank you. Thank you. Actually, it was the end of the table, but that's okay. You're here now.
Good
And
morning.
the chair recognizes Representative N. Murphy to distinguish you from all the Murphys.
Yes, thank you. Good morning, Chairman Pearson and honorable committee members. For the record, I am Representative Nancy Murphy, representing the town of Merrimack. I'm here this morning to introduce HB 177 on behalf of a constituent, special ed advocate, who discovered a need to clarify some language relative to RSA 193:27. HB 177 simply restores the reference to RSA 193:27 that was added through HB 1511, but that was then essentially removed when a second later bill, HB 1639, went into effect. Two bills, HB 1511 and HB 1639, were introduced and passed last year. Both made changes to the same paragraph of RSA 186C, New Hampshire Special Ed Law, with the first adding a reference to RSA 193:27, Roman numeral 8, episode of treatment, that was not in the second bill. I reached out to OLS in August to make sure that it was going to be a bill would be required to correct this, and I was assured that it would indeed be required, that there was an oversight and that we had to do this legislatively. So I filed the LSR. On July 1st, HB 1511, which amended RSA 186C 190B, adds a reference to RSA 193:27, Roman numeral 8, the episode of treatment, went into effect. Just a few months later, on October 1st, HB 1639, which also amended RSA 186C 19B, went into effect.
So from July 1st till October 1st, the language or 193:27(7), which is the episode of treatment, was included in RSA 186C19B 1A. Then it was removed or just miraculously disappeared on October 1st when HB 1639 went into effect. Further compounding things, up till December 1st, it remained that way. And now all of a sudden, there's a change, but not quite an exact change. So really, this really simply is a housekeeping bill, which just clarifies and distinguishes what the bill should say. And I would ask that I've requested an OTP recommendation, and I would thank you for your time for helping end this circuitous language.
Circuitous discombobulation.
It is.
Any questions? Look, I'm only a 1L. I'm glad you gave me all of this
That's
stuff.
it. That's really the Reader's Digest version of the whole thing.
Yeah,
with
thanks.
the applicable laws. And the
Any
dates.
questions? We are good, and thank you.
Thank
And
you
you can
so
sit and
much.
watch History Made if you
Thank
care
you.
to. Jenny O'Higgins signed a pink card in case we need clarifications. I think we're clarificated. But you can come on up and it's billable.
Good morning. Thank you. I'm Jenny O'Higgins. I'm the Legislative Liaison for Behavioral Health at DHHS, and again, was just an optional speaker to provide info. So we believed that the statute actually wasn't really being changed because it already is listed in here today. So I think hearing the sponsor's testimony helps to clarify that maybe it's been removed and is looking to be re-added. We do not, though, episodes of treatment are not court ordered. So where this is placed is somewhat confusing in terms of the department's fiscal analysis of the bill, is that they would not fall under this statute to begin with. So I think that we could probably look through the research presented today and talk with Representative Murphy to make sure we're all clear on
Since
this.
I've chaired DHHS Oversight Committee for the last 5 years, you guys are up to the task of finding out what it means, and even if it arguably, is in the wrong spot.
Correct. We will get to the bottom of this.
I know it.
Okay.
Thank you for your testimony.
Thank you.
All right, with that, I would like to close the hearing on House Bill 177 and open the exec session on that, and the chair moves ought to pass. And second, any discussion?
Good to go.
Having heard the Murphy and O'Higgins show? My wife's Irish too. No further discussion. When ready, the motion before us is ought to pass on House Bill 177, moved by the chair, seconded by the ranking member. When you are ready, please call the roll.
Chairman Pearson?
Yes,
Representative DeSimone?
absent presently.
Representative Rice is absent. Representative McMahon?
Yes.
Representative Nelson?
Yes.
Representative Seidel?
Yes.
Representative Love?
Yes.
Representative Corzine? Yes. Representative Markel?
Yes.
Representative Petrino?
Yes.
Representative Shore?
Yes.
Representative Levesque?
Yes.
Representative Gregg?
Yes.
Representative Raymond? Yes. Representative Georges?
Yes.
$13 to nothing.
13-0, the motion passes. And this ends the exec session on 177. Let's take about a 5-minute break.
Gonna go to consent?
Oh, yes, dear. What? I would love that on consent. Would anybody else love it on consent with me? Great. Thank you. It goes on consent. I open the exec session on House Bill 320, an act relative to enforcement of marital property settlements, and the chair recognizes Representative Markell for a motion.
Thank you, Mr. Chairman. Yes, on this bill, I would move that it ought to pass.
Ought to pass. And anyone want to be a second on this? Representative Georges. And Representative Martel, would you like to convince us?
Okay, well, what this bill does is basically as the law stands right now, there is no requirement that a court actually enforce its own orders relative to property settlements and divorce under RSA 458, I think it's 16A. What this bill does is set out measurable standards by which enforcement is required, or to put the parties in the event an enforcement or contempt action is brought. And what this does is that it puts in measurable standards by which the parties in a court can understand whether an enforcement is warranted either in whole or in part, and whether any portion of the either agreement or court-ordered decree is unenforceable for any of the specified reasons. The specified reasons include, but are not limited to, invalidity due to duress, mutual mistake, fraud, deceit, material non-disclosure, coercion, or impossibility, or illegality of subject matter. If for some reason it cannot be enforced exactly as written, what the bill does is provide that the court can create remedies that will put the parties in the position as if the decree were to be fully performed. And the other nice thing about it is that it leaves out clear, since we've repeatedly heard that approximately 80% of the representative people who are in the family division one of them is unrepresented. What this bill is, it lays out the standards by which somebody can effectively plead their case. And finally, what it does is that it provides a measurable yardstick in the event an appeal is necessary. So once again, I'm going to ask that the committee vote ought to pass. Thank you.
Anyone else wish to share on this bill? Hearing none. The motion is on House Bill 320 relative to enforcement of marital property settlements, moved by Representative Markell, seconded by Representative Georges. And when ready, clerk may call the roll.
Chairman Pearson,
Yes.
Representative DeSimone,
Yes.
Representative McMahon,
Yes.
Representative Nelson,
Yes.
Representative Seidel,
Yes.
Representative Love,
Yes.
Representative Markell,
Yes.
Representative Corzine, yes. Representative Petrino,
Yes.
Representative Shore,
Yes.
Representative Levesque,
Yes.
Representative Gregg,
Yes.
Representative Raymond, Representative George,
Yes.
and Representative Malone is not here. 14-0.
14-0. The chair calls on Representative Gregg for a reminder.
Well, this has an FN, so can it go on consent calendar, or? I don't believe it can.
Is it an early bill? I don't have that
I don't know.
chart handy.
Dealer's choice.
I'm sorry? Well, let's say it does until they ply it from our hands, okay?
We're on consent?
Consent unless they take it away from us. All right. And now I open the exec session on House Bill 335. An act requiring the courts to order a minor and their, should be his or her, family to have psychological evaluations and, if necessary, counseling where parental rights and responsibilities are contested in a family court matter. Chair recognizes Representative Markell for a motion.
Thank you, Mr. Chair. I move that this bill be deemed inexpedient to legislate.
Thank you. And I'm going to suggest Representative Raymond. I saw her hand first. I've worked all summer at trying to see her hand, and there it was. Representative Markell, defense of your motion, please.
Okay, this bill, if it became law, would require the services of a clinical psychologist to diagnose and treat certain enumerated psychological conditions and would require a licensed psychologist to evaluate and file a risk assessment report in 8 weeks or less. There is no showing that there are enough licensed psychologists in this state who can or are willing to perform the kind of evaluations required by this bill. Further, this bill's procedural requirements demand that a court order a risk assessment within 14 days of the initial petition of divorce and fails to consider the large segment of children who are subject to parenting petitions and not divorces. So I once again ask that the bill be considered ITL, inexpedient to legislate.
Anyone else wish to speak to it? Representative Raymond.
Thank you, Mr. Chairman. Just to add to Mr. Markell's concerns, I also have significant concerns about how this bill impacts our bill that we passed last year, saying that that any psychological services ordered by a court have to be covered by the party's health insurance unless they both agree otherwise. And in this case, the risk assessment that they're asking for cannot be covered by insurance because it is not a recognized service that is provided. Risk assessment in psychological circles terms means like a suicide risk assessment. It doesn't mean any of the things that are listed here. And then I also have some quibbles with some Supreme Court cases that make this potentially unconstitutional. So I get where they're going, but I concur with Mr. Markell.
Thank you.
Anyone else wish to speak on the motion? The motion before us is House Bill 335, requiring courts to order a minor and their family have psychological evaluations and, if necessary, counseling where parental rights and responsibilities are contested in a family court matter. The motion is ITL, made by Representative Markell and seconded by Representative Raymond. Would the clerk please call the roll?
Representative, Chairman Pearson,
Yes.
Representative DeSimone,
Yes.
Representative McMahon,
Yes.
Representative Nelson,
Yes.
Representative Seidel,
Yes.
Representative Love, Representative Corzine, yes. Representative Markell,
Yes.
Representative Petrino,
Yes.
Representative Shore,
Yes.
Representative Levesque, yes. Representative Gregg,
Yes.
Representative Raymond, Representative Georges,
Yes.
14-0.
You did?
Thank you. Yep.
I would love that on consent. Thanks for asking.
These are for Representative
And so, Representative Markell, here are two forms whereby you can take your excellent defense of your motions and put it pen to paper.
Well, Mr. Chairman, thank you. What I did was, given my notoriously illegible handwriting, what I did was I typed them up, and if I was wondering if I can affix them to the form. Can
I
do
think the
that?
affix is in, yeah.
Okay. Thank you, Mr. Chairman.
Pass them back. I
Yes,
have
sir.
to read
Thank
them
you.
next.
Thank you.
This wonderfully ends our exec session on 3:35. Oh. Next up, and lost it. I did lose it? Did I lose it? Oh no, there it is. Open the exec session now on HB 350. Yes, and please pass your amendment down. I have another amendment as well. And this is requiring that all family division hearings be video and audio recorded and broadcast live. And the chair looks to Representative Seidel for a motion, please.
Thank you, Mr. Chairman. I'd like to move to ITL. House Bill
Move
350.
ITL, and I need to have a second on that. Second is Representative Gregg. And I believe this is where amendments can be looked at. Is that correct, Representative Petrino? There was a motion, but that gets the bill in play. Now we can have motions for amendments, yeah? I think so. Let me pass them around so you can look at both of the amendments. And I may not have divvied them up evenly, so this is one amendment. That's they already have Representative Love's amendment. If you don't, you can get a second. All right, make sure that you have an amendment by Representative Love, and then you will be given a Representative Kutab.
Mr.
amendment.
Chairman, we
What?
are several short of Representative Love's. Oh, okay.
We have achieved nirvana
Yay!
here.
Thank you, sir.
Excessive celebration is in order.
I like my
And here's a
papers.
pile of Kutabs. I'll swap you a Kutab for a. Yeah. And take a minute to read over both of them, please. To amend a bill that's already been moved as ITL is a fool's errand, and I think that was a procedural problem on our end up here. So, Representative Seidel, do you wish to pull your ITL motion?
Yes, I'll withdraw my ITL motion.
And who seconded that? Representative Gregg, you wish to pull that? Okay, so would you now make another motion, please?
So I will move to OTP amendment number.
No,
Oh,
just
no,
the
I'm
bill.
sorry.
Just the bill. And would you make that motion knowing amendments are coming? Yeah. Okay, who will move OTP with Representative, because we have two amendments coming. Who will second Representative Seidel's motion? Representative DeSimone. E. Okay, so that's the motion on the floor. And now we have amendments. Representative Love, would you care to move your amendment, please?
I move OTP.
Okay, anybody wish to second it? I see no second. I'll give it another 5 seconds. Okay, this amendment does not carry. And now we have amendment 0441H. Does somebody wish to move that? Okay, Representative Seidel moves OTP on the
OTP.
amendment, and who wishes to second that? Representative DeSimone. And just read it again. What it does is it establishes a pilot program so that the original bill's intent may be looked at. I am going to assume that the Ninth Circuit has approved doing this, and they're not going to wake up tomorrow realizing they got to do it. Does anybody know that for sure? Or for certain, sorry. You know that?
Unfortunately, we've not had testimony on that, so we can't assume that. Unfortunately, we've not
Okay.
heard that.
There is no assertion that this is non-germane, is there? No, it looks pretty germane to me. All right, it's just whether you like it or not. Okay, I would assume somebody's done her homework on this. Otherwise, it just dies there. Any discussion on this amendment? Representative DeSimone, you want to jump in? No? Yes, Representative Raymond.
Thank you, Mr. Chairman. And I appreciate the effort by the sponsors of the amendment to address some of the concerns that came out during the public hearing. I think there was a good faith effort here. I still think it falls short of addressing my most critical issue, which is the right of the child to confidentiality. And so just because I'm not aware that many of these cases are open, but on line 18, section 3 says nothing in this section precludes any person or media outlet from recording a family division proceeding according to existing court administrative rules or orders. And then it doesn't say anything about the disbursement of the recording that a media or a random person might make. And I just really worry that this is going to end up in a situation where we have children whose information about domestic violence, child abuse, their medical, their therapeutic records, any of that could get out on the internet forever. And I just think that's wrong. So I can't support anything that would allow the recording and potential disbursement of matters that involve child information.
DeSimone.
Thank you, Mr. Chairman. We've heard quite a bit of testimony through the years concerning the issues of being able to record proceedings in family court and the issues that constituents seem to have with what goes on in family court. I think that the pilot program can at least give us more information to go on before we actually pass any laws that say that it will be in effect forever. I'd rather see a pilot program happen than to have nothing happen. I think it's time we address the issue and help our constituents.
Representative Petrino.
Thank you, Mr. Chairman. Mr. Chairman, I thought that Representative Raymond did an excellent job articulating some of the concerns we have with the underlying bill, and which we at this moment can't support. So having a pilot program to test out something that ultimately we're going to say no to without significant changes, to me, is a moot point.
Representative Scher.
Thank you, Mr. Chair. I can't, in addition to what Representative Raymond said, which I thought was very thoughtful, I can't support a bill when we don't know whether the Ninth Circuit has been consulted on this. I would need, even if I got over Representative Raymond's problems, I just can't. We would need to hear testimony from the court that they can actually do this.
Representative Gregg.
Thank you, Mr. Chairman. So this goes back. I can't, of course, we're discussing the amendment, but it really reflects on, because it's a pilot program, of what the bill states. And so we already talked about the bill and the complications we have in these court cases, and persons not always being their best selves, for things that can be out there. And I agree with what my colleague from Nashua said, as far as those things being out there. Also, this right here under this amendment says that these recordings made under this section shall not be considered the official transcript. That really is kind of the precipice for the people that wanted this bill in the first thing to have this official document or whatever. So it kind of deletes the purpose they wanted it for. Also, it is my understanding that judges do have their discretion whether or not something is recorded already. And so there are certain times where people can record in with their cases, and that is an option. So once again, I think this is part of the judiciary branch. I think that what we're trying to do here is put a heavy regulation on them because of some high conflict situations we've heard about, which are just not the greater amount of them. And I know we like to say, well, 1 or 2 cases could be too much, but this is really a situation where if they are having issues with transcripts or recording or anything that we have talked to them in our special committee about that and how that goes about. And that's really an oversight for them. This is not something that we need to be Big Brother with cameras in there.
I would like to underscore what the representative just said, is that some of the bills we've been looking at here are things that can be addressed in depth in a subcommittee on family court, which will be created. Anything else by anybody else? First. The second, Raymond.
Thank you, Mr. Chairman. I just wanted to say that I know we're not considering the Love Amendment because it didn't get seconded, but one of the things that kept coming up was wanting a complete audio and video transcription and not having the judges have the ability to turn things on and off. And I think that that's something that really would get to the heart of the matter more than a pilot program letting somebody randomly off the street record these things. So I still have the same problem with the media outlet. But.
Anybody else? Motion before us is the amendment 2025-0441H to House Bill 350-FN. The amendment is moved by Representative Seidel and seconded by Representative DeSimone. When the clerk is ready, please call the roll.
Chairman Pearson?
Considering that the subcommittee can look at these questions, no.
Representative DeSimone?
Yes.
Representative McMahon?
Yes.
Representative Nelson?
Yes.
Representative Seidel?
Yes.
Representative Love?
Yes.
Representative Corzine? Yes. Representative Markell?
Yes.
Representative Petrino?
No.
Representative Shore? Representative Levesque?
No.
Representative Gregg?
No.
Representative Raymond? Representative Georges?
No.
Seven.
The result of the voting is a 7-7 tie, which means the motion to the amendment fails. Now we are back to the original bill. And my notes say that this was moved by Representative Seidel and seconded by Representative DeSimone. This is the bill without amendments, requiring that all family division hearings be video and audio recorded and broadcast live. Would the clerk please call the roll?
What is the motion, Mr. Chairman?
OTP, Seidel and DeSimone.
Excuse me, Mr.
She
Chairman.
pulled it and she
Oh, that's right.
This is on the bill, and the motion was ITL, but withdrawn.
Right.
And now the motion is OTP. Representative Seidel made the motion, and you seconded original one. Okay, then, for the chair is confused. Representative Seidel, let's back up. Do you wish to clear the deck and start again?
Start afresh.
Yeah.
I wish to move House Bill 350 ITL.
ITL, Representative Gregg for the win. Oh, I love this committee. Don't you love this committee? I mean, I love this committee. And excessive celebrations afterwards are encouraged. The motion is ITL, Seidel and Gregg. Clerk, please call.
Chairman Pearson?
Yes.
Representative DeSimone?
Yes.
Representative McMahon?
Yes.
Representative Nelson?
Yes.
Representative Seidel?
Yes.
Representative Love?
Yes.
Representative Corzine, yes. Representative Markell?
Yes.
Representative Petrino?
Yes.
Representative Shore?
Yes.
Representative Levesque?
Yes.
Representative Gregg?
Yes.
Representative Raymond? And Representative Georges?
Yes.
14-0. You know, it's funny you should say that. I think so. Anybody disagree with consent? Now, who would like to write? Who would like to write the committee report on that? Who would like to write the committee?
Going twice.
I've written a committee report because I was going to make the motion, but I'm happy to
Are
let
your rates
Representative Seidel do it if she wants.
Are your rates reasonable to sell reports?
Is there a rule that the person making the motion has to write the report?
No, it's a threat, more a threat than anything.
I would
But like my colleague, Mr. Markell, I typed something up so that you'd be able to read my handwriting. Should just,
I'll leave that up to you.
Would you like to do it?
yeah, I'm fine to do it.
Just throw in a lot of love, since
Already done,
all
exactly.
the
I'm like
coast.
scratching away over here.
Maybe we should just let Representative Seidel write it then, and she can just steal from me or not what she wants.
It's not stealing, it's research.
Research.
Okay, Seidel, yes. This this concludes the exec session on 350, and opening the exec session on 433, making 17 the age of consent for marriage if either party is active duty military, and removing language regarding age waivers for marriageable registration records, since age waivers are no longer issued in New Hampshire. And would you like to make a motion?
I would, Mr. Chairman.
What
I
would that be?
move ought to pass.
And do we have a second on this? Representative Seidel.
What's the marriage?
And would you like to both do that and speak to your motion?
Thank you, Mr. Chairman. I would like to speak to my motion.
Thank you.
This bill only considers young people who, young adults who are in the military being able to marry. When we are in the military, and although I was over 18, my husband was in the military and away frequently during the first few years of our marriage. It was very difficult for me as his spouse to be home with children while he was away, and he was never in any one spot for any length of time, so I could not join him. However, most of the time today, that was during the Vietnam War, but most of the time today, the spouse is able to join the military person and continue their marriage during that time. And any children born of that marriage would immediately, as a rule, be able to meet their parent. If we kind of take a look at this and you see a young person, let's use the scenario that the male of the marriage is in the military and the female is the 17-year-old. First of all, the male at 17 can join the military with his parents' consent. So if they were to marry, the spouse would have to, if they were not able to marry, the potential spouse would have to stay home, possibly give birth to a child who may not meet their father for up to 4 years. Because the spouse, the parent, the other parent of that child can't live on base with the father. It seems unfair to the child as well as the other person who may turn 18 within a few months. But I know for a fact when you're in basic training, you cannot leave the base while you're in basic training. So even if it's a week, 2 weeks, a month, you cannot get married. So I just feel that this would create an opportunity for good, solid families. You know, the clock turns at midnight and makes you 18 the next day. It's not magic that you all of a sudden become an adult. You either are or you're not. That magic clock doesn't make it that way. It's who you are inside that makes it that way. Being married when I was just months after 18 didn't make me any more of an adult than I was when I was 17. I was a mature adult, period. My husband was a mature adult, period. I just think this gives an opportunity to create good, solid families. Thank you.
Representative Petrino.
Thank you, Mr. Chairman. So, more often than not, what we're talking about here is the female spouse under the age of 18. Regardless, she is still a minor. At 17 years old, she is a minor. And that's something I just cannot wrap my head around, how we can support having children get married, regardless of any other circumstances. Again, more often than not, we are talking about a female under the age of 18, a minor. Thank you, Mr. Chairman.
I might suggest that if this bill were to make 17-year-olds child brides or grooms, it would also make 17-year-old child soldiers.
May I respond to that?
Please do.
I fully agree.
Representative Craig.
Thank you, Mr. Chairman. Knowing that we just passed a bill last year that that just became enacted. We haven't even had a full 2 months of that yet. And we had a lot of deliberation on what that was, and made the good decision that we wanted to raise the marriage age to 18 in this state. We've not seen any complications from this yet. As a matter of fact, the prime sponsor was a happenstance, kind of a made up scenario that she thought could be a problem. We haven't seen any real world problems from this. And so knowing that we all deliberated very hard, that we came to good judgment that the world is not what it used to be back in the 50s, 60s, whenever people got married a lot younger. I think that we are wise to stick with that until we have real complications. I also want to say that having a service person who is not married, who has a family, does not mean they can't live with their family. As a matter of fact, the military makes it even for a single person, you don't have to live on base. They have something called basic allowance for housing, where they actually provide that money. They don't say, is this your spouse or whatever? They actually give you that allowance. Even back in the late 90s, I knew somebody that was in the military, and they were just engaged and ended up getting pregnant, but they were able to have this housing allowance off base. It was not a problem. They didn't have to be married. So that's a problem that we're kind of coming up with that really isn't a problem, because the military is happy to take care of the families even if they're not unified in marriage yet. So I would say that we should ITL this.
Representative Georges.
Thank you, Mr. Chairman. I know the life we have today, all our mothers, or what they married when they was young. But today, I saw a lot of girls who are suffering, not because it's just from military, but because to be married in the early age, but they never do anything, but they become a problem. And where I came from, they make a young girl to be married. But today, I don't think so, because they suffer a lot. Make a 17 years old girl, I don't know, but as a mother, I'm not going to accept it for my children. No, that is not helping girls. We need to help our children. We are here to help, to change, to be the change agents. If we want to be the best world, we want to be for the best future for our children, we are the ones supposed to make something to make them feel better. We already have experienced ourselves suffering. Why are we going to let again our children to suffer? Because when you are 17 years old, maybe when you become 20, 25, it's going to be divorced, or they're going to be separate. But you never finish, you never do anything. We're the one who need to give ready future for the children. Thank you.
Representative Levesque.
Thank you, Mr. Chair. I definitely don't support this bill, mainly because I think that this could cause a lot of issues, considering that at 17, they can still back out of the military. It is a promise to go in, and then at 18, if they continue that promise, then they can join, but they can still back out until they are 18, because you need a GED or a high school diploma, and you need to pass each military branch's test in order to join the military. And there is no spousal housing at basic training. You are basically housed in bunkers with your trunk that you take, that are given to you, and that is it. You are not given spousal housing until after basic. And my dad's veteran of the Air Force. My mom was a spouse, and they always told me about all their stories. And I just remember this one young girl my mom told me about, whose husband gave her frozen hamburgers to last until he came back. She had a mental breakdown because she ran out of hamburgers and didn't know how to cook herself a full meal. And she luckily had an intervention from a pastor, who the other spouses saw something going on and suggested he go over to her house, where she had a full breakdown saying she ran out of hamburgers a couple days ago and didn't know what to do, and didn't know if she was going to be able to have food until her husband came back because of his extended deployment. that is what is the reality of happening, because we are sending young girls who are unprepared into a marriage. I have friends who don't know how to do their own laundry. I have friends who don't know how to make their own mac and cheese at 25. I go to a college student's campus at the dry cleaners, see how many students know how to do their own laundry. It is astonishing, because not many parents think I have to teach my 18-year-old how to do their own laundry. But it is the truth. I was 9 when I went to the laundry mat near my house, and a man was surprised that I was doing my own laundry when some of the college students couldn't even do it at 9. So to think that they are mature enough to handle adult responsibility of their spouse away on deployment, on basic, and to be able to provide for their child, to provide for themselves, is astonishing. And I don't think that this bill is the intent that the sponsor really wants.
Representative Seidel.
Thank you, Mr. Chairman. I'm questioning, how are we okay when parents have to give consent for their children to go off to war, to go off to the military? And we're okay with that for when they're 17. If they're saying you're ready, you're ready. But we're not okay to say to another child, if you're not mature enough to marry, you're okay to go to war, possibly lose your life fighting for your country, handling weaponry that we will never see in the private sector, but they're not okay to make a decision of marriage. We're supposed to be trusting parents. There are parents that we can't trust to raise their children, but the majority of parents use good judgment with parenting, and I doubt very much would say, go off and get married if I don't find you're mature enough. That's where I come from.
Representative Raymond.
Thank you, Mr. Chairman. Well, actually, the military doesn't send kids off to war at 17. You can join basic, you can join the military at 17 with parents' permission, but you cannot be deployed, and it is not a permanent enlistment until you turn 18. Up until midnight on the night before your 18th birthday, 17-year-olds can change their mind legally in the military. It doesn't happen very often, but it is allowed, and it's very clear. I mean, you can Google it. It's out there. It's very clear. Marriage isn't like that. You can't, 2 weeks later, be like, oh, this was a mistake and I regret it. Now there's a whole process. And for me, I guess the bottom line is 2 things. One, I don't think we should reverse a bill that we just passed last year for very specific, great reasons. And 2, the testimony that we had here from the women who are current military members who were married off at young ages and had such horrific experiences. I just feel like it would be I can't listen to their pain and then say, well, I think I know better than you what's out there. I can't do it. So I cannot possibly support this.
Representative Cozen.
Thank you, Mr. Chairman. I get lost in the weeds here when it comes to the fact that our state as a whole has decided that it's okay for a 17-year-old to have sex. And that's perfectly acceptable as long as the person's within three years of their age or whatnot. It's consensual. So we're okay with letting them have sex, but we're not okay with letting them get married. To me, that makes no sense.
Anyone else wish to speak? Representative Nelson.
Thank you, Mr. Chairman. I just wanted to say that this is a very specific and particular carve out that would be utilized very rarely. And also the very, very sad and awful situation that occurred with that one woman in particular who was married at a young age to a military person. She told us that that person was much older than she was. And this would not happen in this case, in the case of this bill. Thank you.
Just to clarify, nothing in this bill prohibits
Representative Raymond.
Thank you, Mr. Chairman. Sorry, nothing in this bill prohibits someone of any age to marry a 17-year-old as long as that person's in the military. We could have, you know, a 75-year-old man marry a 17-year-old girl as long as that 75-year-old man was in the military, based on the language of this bill.
I'm not going to do it.
I mean, I don't think it's a good idea, but if the parents were okay with it, this bill says that's okay.
Representative Gregg.
Thank you, Mr. Chairman. And to kind of like reflect on the weeds part of this and how we have this consensual age at a certain age, and then we raise the marriage age. First of all, they're two very separate entities. So when we're talking about the marriage, we're only talking about that. We're talking about the ability to be in a contract. We're talking about the ability to be able to get services as a minor, which even though we have this idea of an emancipated minor once they're married, we do know that there are many shelters that will turn women away if they're not 18 because there are liabilities within this. So this is more of a legal nature. Yes, you know, the choices that we all make when we're younger can be complicating. However, this is about legally binding documents. We literally just passed this bill. I mean, this has been something that Representative LeVake has worked on for a very long time. We were, you know, looked at as really making a forward effort because we understood too that in a day and age when we have much more worry about sex trafficking and everything else, we did not want to be a beacon for this, for people to say, oh, well, I can go here and marry a minor. There were a lot of things that went into this, but certainly if you want to raise the age of consent, we need to look at that at a different time. But this bill stands on its own with the problems that it has.
Representative DeSimone.
Thank you, Mr. Chairman. I've heard a lot of discussion, and with all due respect to the people who are very concerned about this, number one, I was doing laundry and caring for my siblings when I was 6. So it has nothing to do with age as to whether you know how to ration your hamburgers. The other thing that I've heard is that a person under the age of 18 cannot go to a shelter, and the shelters that in the state of New Hampshire that I called said they would absolutely be accepted into the shelter. The other thing is that we have young women who are leaving their parents' homes and moving into homes with men who are older than them and being abused left and right. The cohabitation is of usually young women who are less mature than the woman who is going to make the decision of, I want to marry the man I am going to be with. That takes maturity. There is a big difference. We have to look at the very few, I repeat, the very few women who are going to want to enter into marriage with a person who is in the military. We're not talking about hundreds of women. We're talking very few. Those are women who are making a mature choice. And lest we forget, the bill does require written permission from a parent or legal guardian. It's not that this kid can just go out on their own and get married. They have to have permission from the family. Thank you, Mr. Speaker. Mr. Chairman.
We have one more bill to exec after this. So if anybody has anything new to add, fine. If not, I'd like to move this along. New, promise? Okay.
Thank you, Mr. Chair. I have been fighting this issue since I was 15. The military argument has brought up time and time again, and I just wanted to say that I have received so many stories. I still receive stories of people from the streets. I will just saying that their parents gave permission for them to be married at 16, at 17, and they were married off to a man that they did not love, that they feared for the however many years that they were married. And it wasn't until they reached a certain age that they realized I can leave. And sometimes they have to leave their kids behind, which they never want to do. No mom wants to make the choice between my life and my kid's life of that situation. But sometimes there are parents, there are mothers that have to leave their kids behind because their husband is so abusive. Some of them haven't seen their kids in years. And I'm just afraid that this would open up the door of abuse and neglect when it comes to these children that we do not want in this state. And also, there is no active duty military base in New England. It is all out of state. Thank you.
The motion before us is ought to pass on House Bill 433, making 17 the age of consent for marriage if either party is active duty military, and removing language regarding age waivers for marriage registration records, since age waivers are no longer issued in New Hampshire. Moved by Representative DeSimone, seconded by Representative Seidel. Would the clerk please call the roll?
Representative DeSimone,
Yes.
Representative McMahon,
No.
Representative Nelson,
Yes.
Representative Seidel,
Yes.
Representative Love,
Yes.
Representative Corzine, yes. Representative Markel,
Yes.
Representative Petrino,
No.
Representative Shore,
No.
Representative Levesque,
No.
Representative Gregg,
No.
Representative Raymond, Representative Georges,
No.
and Chairman Pearson.
Yes, and it makes it a 7-all tie.
One thing that didn't come up in the discussion.
Yes,
Mr. Chairman, I'd like to make a motion to ITL.
I will accept a motion to ITL. Representative Gregg. And a second to it. Representative Levesque. Got to put all the letters in there nevertheless. And should this come out a tie, then it will go on with no recommendation, but 2 reports. I think I'm correct on that. But there had to be another motion since that one ended in a tie. The motion before us is ITL, moved by Representative Gregg and seconded by Representative Levesque. And again, put me at the end, and the clerk will call the roll, please. Yes. What? That's okay. All right, got it, sorry. Like she said, when the clerk is ready, please call the roll.
Representative DeSimone,
Yes.
This is ITL.
Oh, I apologize. No.
Representative McMahon,
Yes.
Representative Nelson,
No.
Representative Seidel,
No.
Representative Love,
No.
Representative Corzine, no. Representative Markel,
No.
Representative Petrino,
Yes.
Representative Grossman. That's right. Representative Shore,
Yeah, no. I mean, yes. I take it back.
Representative Levesque,
Yes.
Representative Gregg,
Yes.
Representative Raymond, Representative Georges,
Yes.
and Chairman Pearson.
No, which forces a tie, so I need 2 reports coming out of here. Do I have volunteers for The, wish the bill passed? Who would like to write that? We do need a report. Why, look at that. Through the wonders of modern technology, an unsigned report.
Okay.
You want to do it? You should get this one.
Okay,
And this is
so
yours, is it? So it needs to be signed? And those reports need to come to me for final look at.
This, who's doing the OTP one?
I am.
DeSimone?
Oh, Madam Vice Chairman,
She's already-
you've already done it.
Yes,
Okay,
ma'am.
thank
Right
you.
there.
You can buy these on the open market, you know?
I know it.
All right, I will put this in my look at pile. And Representative Petrino, you're going to write, no, we already said, you, are going to do that. With that, that concludes the exec session on 433, and let the House floor fight it out. Open the exec session now on House Bill 486, which is relative to grandparents' rights, and I believe the bill's prime sponsor, Representative Nelson, will make a motion.
Thank you, Mr. Chairman. I make the motion ought to pass.
And do I have a second? Representative Gregg?
Thank you. Oh, I apologize. I'm sorry,
I
Mr.
did give
Chairman.
you another clerk to help you.
Yes, I know. Just so briefly, the topic of amending this RSA came about from one of my constituents who had guardianship of her grandchildren at different times because of their mother's struggles. And when I researched it, I found out that we have up to 12,000 grandparents who are raising their grandchildren, having permanent or temporary guardianship custody. And we also realize that we have a really big problem with substance abuse disorder. And we also know that although the goal is reunification with the parents, it can be a bumpy road for recovery. So this bill really just adds language that enables a grandparent or grandparents to have positive, consistent relationships with the grandchild because it's in the best interest of the grandchild. And it also gives a little bit of help with the judges because the word divorce was being interpreted several different ways. So I helped add a little bit of language that will help determine whether grandparents should have a visitation or not. Also, just wanted to make it really clear that I also kept in mind and very carefully tread on the fact that I realize that it is a parent's constitutional right to make decisions about their children. And so also wanted to mention that this bill was two big parental rights folks in New Hampshire did sign on in support of this bill. Thank you.
Representative Gregg?
Thank you, Mr. Chairman. I just wanted to commend the representative for her work on this. I think this strikes a good balance with understanding that parents should have that that first right in healthy situations, but also understanding that grandparents do and can play a very integral role with kiddos. So I appreciate that language.
Thank you.
The motion before us is ought to pass, moved by Representative Nelson, seconded by Representative Gregg, on House Bill 486 relative to grandparents' visitation rights. The clerk, please call the roll.
Chairman Pearson,
Yes.
Representative DeSimone,
Yes.
Representative McMahon,
Yes.
Representative Nelson,
Yes.
Representative Seidel,
Yes.
Representative Love,
Yes.
Representative Corzine, yes. Representative Markle,
Yes.
Representative Petrino,
Yes.
Representative Shore,
Yes.
Representative Levesque, Representative Gregg,
Yes.
Representative Raymond, Representative Georges.
Yes.
The bill passes unanimously, 14-0. The chair calls on Representative Gregg for a suggestion.
Would you like this on consent?
Why, I would love it. Would my friends love it too?
Yes.
What?
It has a financial note.
Well, they can ply it from our hands if they want it.
They may not be early bills.
Oh. Let's say yes, and they can always take it away.
Kick it off.
Right.
We gotta go for lunch.
Yeah, I don't have my chart on early and late. It's in here somewhere. This ends the exec session on 486, and it begins our lunch break. Try to be back here around 1 o'clock or so, please,
Thank you, everybody.
because we're going to be dealing with the parental rights bill all afternoon. Attorney Williams may approach.
Another paper.
Latest and greatest. That's what the speaker wants.
Oh, it's not the same one we got last week?
It's not. Mr. Chairman, do you want me to pass these out yet? Okay.
There he is. Come on, afternoon.
Oh, you decided to check out for the show.
For a good time. Hoffman Packard, and I'm the representative from Londonderry, Rockingham County 16. And today I am here to introduce House Bill 10. And to make things clear right away, this is the original version of House Bill 10. We have amendments that pretty much replace the whole bill. So, HB 10 establishes the Parental Bill of Rights. And this is in response to growing concerns from parents about government overreach and in the decisions of their children. I have had so many parents from my community and from across the state come to me and tell me that they are the ones that are responsible for the upbringing of their children. The schools are there to teach them. The parents are the ones that are responsible for their health, their upbringing, putting a roof over their head, feeding them. That's what the parents' responsibility is. The schools are not the responsible party when it comes to raising the child. They're there to teach a child, not to raise the child. That is what the parents' responsibility is. That's why we need a Parental Bill of Rights. The amendment requires full transparency in programs affecting their children. Parents have the right to access all records related to their children's education, health, and safety, and ensuring no decisions are made without their consent. Family is the foundation of a free society, and protecting parental rights strengthens that foundation. I urge my colleagues to support this amendment to reinforce the role of parents. And with that, Mr. Chairman, Representative DeSimone is the one that put the amendment together. So, and I've read it and I understand it, but I don't understand it like she does, seeing that she's been sitting on this committee for a number of years. And instead of me fumbling through it, I am going to let Representative DeSimone go through the amendment so everybody completely understands it.
So
but
ordered.
remember, what I'm asking for is the committee to accept the amendment when you go into executive session, and which replaces the original bill. Thank you, Mr. Chairman.
So ordered.
Thank you, Mr. Chairman and committee. Deborah DeSimone. I represent Rockingham County District 18, Atkinson. I'm kind of new at this. This is my 9th term. So I've only been at it for 17 years. And I say that kind of tongue in cheek because parents have been at it a lot longer than I. When I read House Bill 10 and the other Parental Bill of Rights bills that have come before this House in years past, I really became very concerned that we have not been able to pass a bill. And I went over every single word, every period, every comma, every T has been crossed. The purpose of this bill is to establish a framework of parental rights regarding the upbringing, education, and care of their minor unemancipated children. It ensures parents are informed about their child's health, well-being, and education while in school custody. I use the word custody only because children are with educators for 6 or more hours in a day, where they are in charge of making sure that our children are safe. key provisions of this bill are parental rights. It's direct education, care, upbringing, moral and religious training of their children. We all have different ideas about the moral and religious training of our children, and we should have the right in this state of live free and die to do that. The parental rights to enroll their children or child in a public, private, home-based schools or other state and federally approved education systems. They should have the right to access and review school and medical records. This has been a right that we have heard from constituents that has been denied for many, many years. Parents have the right to consent to biometric scans, DNA records, and video recordings. It should only be by the parental consent that these things take place. Parental rights should include yearly waiver and consent forms in schools for parents to sign as a part of yearly paperwork. Every year, children are being given for booklets to take home that discuss their educational plan for the year, their student guidebooks, and they have to sign them. Parents should be given the same right. Parents should be notified of suspected allegations and/or criminal offenses against their child or children. We move on to the school board responsibilities. We elect our school board members. We are their constituents, and in a state where we have a constituent legislative body, the school board responsibilities shall include that they shall develop policies to promote parental involvement. Children do better when their parents are involved. They should provide information on course content, clubs, and activities. Again, children do better when their parents are involved. It should allow parents, caregivers to object to certain instructional materials and have the right to withdraw their children from certain health education programs that they deem unnecessary or not to coincide with their moral or religious beliefs. The school board responsibility should be to inform parents of their rights and responsibilities in the student handbook on an annual basis. Parents should have the right to health care services and require written consent for both parents and caregivers for the health care services to include medical procedures except in emergencies. All parents should be able to decide whether their child receives certain medical procedures or not. As far as a fiscal impact, the fiscal impact is not really to be part of the general talking points to the caucus because it's really not necessary to include that. There should be no new funding or positions authorized. There's an indeterminable increase in state expenditures due to potential increase in legal complaints and appeals. So these changes that I've made to the original House Bill 10, I wanted you to all have them because it really tightened up the language. It gives parents the rights to parent their children. That should never be questioned. Thank you for your time, Mr. Chairman.
Will you accept questions?
Absolutely.
Is it true that this current amendment is in part in response to concerns that people had had with the original bill, so that the intent is to make it a better bill?
Yes, Mr. Chairman. I mean, I filed that bill initially so that we could take a look at it and analyze it and come up with an amendment. You know, I didn't know if we have to change the whole thing at the time or change pieces of it. It seems that I know Representative DeSimone and others on this committee, yourself included, have worked for a lot, put a lot of hours into doing this. And so that's where we're at. The original bill had flaws. I think those flaws are have been taken care of.
One of my day jobs is being part-time CEO of a medical center, and my wife is a family practice physician. And something that we have long ago discovered is there is a lot of misunderstanding as to what HIPAA is. And people sometimes, whether they know they're doing it intentionally or not, will say, oh, I cannot tell you because of HIPAA. This question is to either one of you. Has that been your experience, that HIPAA is invoked perhaps inappropriately?
Honestly, Mr. Chairman, my daughter graduated from high school quite a few years ago, and it was kind of pre-HIPAA, so I personally have not been affected by it. I cannot speak for Representative DeSimone, but if I'm correct, it wasn't around when my daughter was in school.
If I may, I'm in the same boat as Mr. Speaker. With all due respect to Mr. Speaker, there's more snow on my roof than his. So my children weren't involved in the HIPAA, but my grandchildren are. And I would not be amenable to somebody not giving my daughter and son-in-law, both my daughters and sons-in-law, information about my grandchildren and their health care. It just isn't right. And Representative Markell, I was just trying to look it up, but it is in the amendment. Representative Markell worked on verbiage to allow for this bill to encompass verbiage to give parents the right to have their children's medical records available to them.
Representative Gregg.
Thank you, Mr. Chairman, and thank you, Mr. Speaker and Madam Vice Chair, for explaining the amendment and the bill. I have a couple questions, so I'll try to do one and then do a follow-up. So is this only trying to codify parental rights? Because everything that you said, I've been able to do with my own children's upbringing without having this codified. But is this just codifying for public schools, or is it also in private, like these parents? What I'm seeing is the parents have the rights in public schools, you're giving it that, but not in the private school settings. Is that correct? Or does this extend to both somehow?
It will extend to both. It will extend to public, private, and religious schools.
Okay, follow-up?
Follow-up?
Thank you for the follow-up. Also, it says that when you're talking about what parents will be able to get, it says, this is on this new amendment, I hope I'm on the right amendment, page 4, line 14. It says the right of a parent to inspect school district instructional materials. The way that it's worded, the right of a parent, but not the parent, does this mean, because I know that we've had an uptick in people complaining to school boards in the last few years, but they tend to travel. There are some that will travel all over the state. So does this mean any parent can go to any school and start to request this information?
It does not. It means that a parent and the reason that I used that is that there, as we know, families come in all shapes and sizes nowadays, and there may be one or more parents in the home. So it doesn't have to be both parents. It doesn't have to be one parent or the other. It could be a parent.
Follow up.
But the way that I'm reading it, because the law is so specific and the gray area always goes, to the wrong side here. So it just says the right of a parent, not like the parent of the student or particular student. It just says the right of a parent. So what I'm reading this too is that I'm just looking at the big ramifications and maybe unintended consequences, that this could be any parent. So I'm a parent, so I can go up to North Country and say, what are you guys doing here? Or, in the South, like start comparing and stuff. I'm just wondering if you plan to specify that more.
So actually you could. What if you're trying to move to the North Country and you want to check out the school system? You want to go in and you want to say, I am a parent of a potential student. I want to know what your curriculum is.
Other questions? Representative Raymond.
Thank you, Mr. Chairman. And thank you both for being here and taking my question. I noticed that there was a lot of changes from last year, and I sincerely appreciate all of the work that has been done. I still have a question about the medical records section, because we have another bill in front of this committee about accessing medical records, and we got quite a bit of testimony about what medical records are and are not accessible to parents under both New Hampshire statutes and federal statutes. So my question is, how does this new paragraph intersect with the laws that we currently have on the books that say that once you're 14 and older, you can voluntarily consent for STDs? That's RSA 141C18, and the ones that say that that children's therapeutic records are deemed confidential, and the Supreme Court case is saying that parents don't have the right to waive confidentiality for their child in those cases. So how does this language on page 2, starting at number 19 of the amendment, intersect with those existing laws at the federal and state level?
Well, it does intersect because if you apply, and Representative Markell can answer this in legalese better than I, and he was my consultant on this. As Mr. Speaker stated, I consulted many experts. So how this intersects is that at birth, a parent can file the paperwork, and Representative Markell can correct wherever I stray on this, to become a personal representative of the child.
Representative Markell.
Thank you, Mr. Chairman, for taking my question. I guess this is going to be a way of a supplemental answer, perhaps. One of the things, and by the way, to directly address your question, you're raising some good points, because there are inherent conflicts in the law when you're dealing with child's records. I think one of the lead cases you may be interested in is In re Berg. It's from 2005. It's a New Hampshire Supreme Court case. Okay, and it deals with the confidentiality of children's records. Okay, bear in mind that very few things in law, at least in my experience as an attorney, are absolute. Okay, and when you're dealing in a situation where there's either going to be a custody battle or there's a competing state interest, which is exactly what Berg deals with, and the accessibility of records, what it says, the key holdings in regard to what you have there is that children have a right to have a therapeutic privilege under RSA 3, I think it's 330A2, I think. And what it said was that the privilege, the patient privilege relationship in terms of privilege, okay, children can qualify for that. So if you're dealing in an adverse situation or where there's going to be custody issues or things like that, the state can step in and exercise that competing interest and can deny parents access to those records. Now, that said, that is not all the time. That's if you're in a court situation. I mean, bear in mind that parental rights are not absolute. So, for example, if you are in a situation where you're in an intact family, there are no custody proceedings, no divorces, no parenting petitions, things like that. These are under normal circumstances where you would be able to access those records. So that right only gets reduced, and the competing state interest comes into play, basically in three areas. One, if there's going to be allegations of abuse or neglect, because you do not have the right to abuse or neglect your child. Number two is that if you voluntarily invite the state in, which means that you either are not married and you file a parenting petition for your children, okay, or three, that you're married and there's going to be a divorce proceedings, then the state can intervene and make sure it's protecting the interests of the children. So these apply generally. And so when you look also specifically at the terms personal representatives, when you look at HIPAA, okay, HIPAA is not, in my reading, is not preemptive, which means it does not occupy the entire field of law, as your question accurately points out, because there are other state statutes. So when you look at that, this basically says a parental representation as the child's representative should, under many circumstances, be able to grant you the access of the records. And like I said, once again, these are under normal circumstances. Exceptions here, for example, stand up particularly when you look at allegations of law enforcement investigation, a crime committed against a child, or, for example, if there is going to be something along the lines of a court order which limits that access. Now, all that said, to show you exactly how convoluted this is trying to make it simple, because nothing in law is going to be simple for the most part. So when you look at it, for example, if you have a guardian ad litem come into a case, okay, where somebody is appointed to represent the best interests of the children, and there may be therapeutic or physician's records that otherwise would be privileged, nevertheless, a court can have the authority to allow a guardian ad litem to waive the child's privilege and be able to obtain the records. So the concise answer is this would be applicable most of the time, okay, but not all of the time.
Representative Raymond, follow up.
Thank you, Mr. Chairman, and thank you for the clarity. So to belabor the point a little bit, this makes an exception for if there is a crime, an investigation of a crime committed against the child. What about those situations that we heard about in testimony last year about the medical records, where a child is telling her medical provider, like, if you tell my mom or my dad that I have asked for birth control, I'm thinking a 16 or 17-year-old, this is going to result in me being abused or neglected at home. Currently, as it stands, the physician would then possibly make a DCYF report, but also, hold on to those records until DCYF does its job. Under this, I don't see a carve out for the physician to be able to say, I have an allegation that has caused me to be concerned enough to call DCYF. Can I hold this record until I get that? Because it's not bad enough to call the cops because it hasn't happened yet, but it's bad enough that their mandated reporter law kicks in. Yep. Is there, what happens when you look at the last line? It says it's a misdemeanor at that point for the physician to say, whoa, slow down. Let's let DCYF talk to the family before we release these records.
Right. Well,
Representative Markell, in the capacity of being one of the amendment writers, and brief, please.
Okay. Well, I don't know that this necessarily addresses all situations under the law, okay? There's going to have to be some flex and some exercise of discretion, okay? I can't speak to that aspect as to whether or not they would subject to criminal penalties. There may be other sanctions that could be taking place that arise within the context of being a practitioner. However, the converse is almost true when you would say do you think a parent ought to know, absent any allegations of abuse or neglect, that their child is being prescribed birth control pills? That's another question I think somebody else is going to have to answer.
I mean, follow up, I would suggest that the
Follow
federal
up.
government has already weighed in on that, and there are a number of statutes that say, no, parents don't have the right to that under federal guidelines.
Okay. Well, when you look at the CFRs, okay, there are issues of abuse. There are issues of whether or not that becomes private, okay, or not. And that's I think, going to have to be a judgment call, and I think it's going to need some further action. Like I said, nothing in this statute is going to be absolute under all circumstances. And if there's a need to be able to protect a child from abuse or neglect, that's a different matter altogether.
Thank you. Thank you for your indulgence.
Any other questions of the speaker? Representative Schur.
Thank you, Mr. Speaker. Thank you, Mr. Chair. Thank you, Mr. Speaker and Representative DeSimone. I want to go back to Representative Gregg's question on page 4, the language starting with line 9 through line 23. All of those use the language, the right of a parent. And I believe Representative Gregg's concern was, I'm a parent of, let's assume I'm a parent of a minor, thank God no longer. And I go up to Coos County to just look at their records. Not because I'm thinking of moving up there, but because I just, as a political matter, I want to find out what's going on up there. I appreciate that concern, and I'm wondering if, for example, on line 11 on page 4, the right of a parent to receive statewide standardized assessment results. If we were to add to that sentence relating to their child, would that be an acceptable limitation on what you anticipate this bill doing?
Representative, I think that this is the second rewrite of the amendment. And if any member has an amendment they want to bring forward, that is something that is your right to do that. So if you had an amendment that you wanted to bring forward, you can bring it forward, during executive session.
Follow up?
The scheduled and announced exec date for this is March 4th. So therefore, we have 2 weeks if anyone should choose to do this. Follow up.
And I appreciate that, Mr. Speaker. I'm just curious whether either you or Representative DeSimone, what you think about that kind of modifying language.
I'm always open to certain languages, but I never make a commitment until I actually see it.
Too bad.
Representative Seidel.
Thank you, Mr. Chairman. And this is actually to address Representative Schur. On page 1, line 14, it gives you the definition of a parent. It means a person who is the legal, natural, or adoptive parent of a minor child. So would that not cover your request?
Follow up
to her, yes.
The way I read that is, as long as I am the legal, natural parent of a minor, I can go to any school district in the state, whether I'm thinking of my child's in that school district or not, whether I'm thinking of transferring to that district, and I can look at their records to be a little too cute about it, just for the hell of it. That's my concern. I don't want just to open the door to, school districts all over the state being getting requests for records that don't relate to their child in that district. That's my concern. And
If I could ask the Speaker and the Vice Chair, would that, I could ask the Speaker and the Vice Chairman if this would materially affect the bill?
May I ask you what would materially affect
If
the bill?
the definition of a parent vis-a-vis a school is cleared to say a parent of a child in that school, what Representative Scher is asking.
Well, Mr. Chair, to the point of, Mr. Chairman, I apologize, to the point of another representative's statement, the definition clearly states parent means a person who is the legal, natural, or adoptive parent of a minor. And I think that clarifies as far as I'm concerned. Again, I will reiterate Mr. Speaker's statement of if anybody else feels that it could be made clearer and you want to bring another amendment, and that's your legislative right to do so.
Representative Gregg.
Just if this.
You're welcome.
Oh, thank you, Mr.
That's
Chairman.
okay.
Sorry, I already thanked you once this
know.
time. No, thank
Would you like an all-day thank you?
Yeah.
Pass?
Can we just do a blanket?
It
thank
would be
you
nice.
for the whole
Okay,
day?
you have
Yes.
one.
I apologize. And thank you for taking another question from me. I just am wanting to make sure, because we do know that gray areas in the law can get weird and stuff. Do you think that if a parent could go do this from any school, and this is going to, by your definition and stuff, include homeschools, include private schools, everything else, that this could financially be a heavy burden if all of a sudden any parent can go to any of these schools and start requesting things? I certainly am worried about the weaponization of that. We've had, and that's, we've had right to know stuff, and it can get very, very costly with any of the schools. Specifically, we're talking about like homeschools and stuff like that. If a parent could do that, do you see where that could be a problem?
Yeah, I think this, the discussion of a parent going to a school 200 miles away is not realistic. Now, I mean, let's be realistic. Why would a parent that's in Salem drive to Berlin and ask for what Berlin was doing if they never plan on being there? I mean, you can possibly imagine maybe somebody might do that, but I think realistically, that's not going to happen.
May I make a request that we move off this subject? Because I think the answer is, if somebody here is really concerned about that, you have 2 weeks to get an amendment to clarify the language to protect the fears you have. Could we do that? Okay. Other questions? Other questions? Seeing none, thank you.
Thank you, Mr. Chairman and members of the committee.
Thank you, Mr. Chairman and members of the committee.
It is a custom in the House that if representatives wish to speak, they are accorded primary consideration. And with that, the chair recognizes Representative Timothy Horrigan.
Thank you very much. I'm President Timothy Horrigan from Stratford County District 10, the town of Durham, and sort of a scary thing being the first one of many to speak against this bill. You've responded, Mr. Chair, you responded to objections from various committee members by inviting them to submit an amendment. I personally feel, just looking at the original bill and the amendment was just published today, apparently, so it's not even on the general court website, so we haven't had that much time to digest it. I think the whole bill is so flawed that I doubt that I can vote for even a heavily amended version. First of all, I think it's basically unnecessary. Parents already have these rights, and if we are trying to enumerate these rights in RSA, it would probably be more appropriate to try to craft a children's Bill of Rights. Obviously, children children are dependent on their parents, so you can't separate one's interests from the others. But I think the children's rights should come first. Of course, the timing, just the phrase Bill of Rights, that's something, you know, we're all in theory in favor of, although there is a lot of, I probably don't want to get into too much, but there's a lot of uncertainty of what's going on in Washington, D.C. about exactly what rights we have, which parts of the Constitution actually apply. That's obviously taking its name from the Bill of Rights, the U.S. Constitution, but that's probably like not really our concern. We're in Concord, not Washington, D.C. In terms of the emphasis of it, I circled a few things. One is there's this, you still have this thing in here. And by the way, I give the sponsors amendment props for making the bill shorter. So that's, they've taken about a page out of it. So that's probably a good thing. Like this whole thing about before any blood or DNA is created, stored, or closed. I don't really know what the purpose of that is. And that also brings me, and in terms of what they are,
It would be helpful, Representative, when calling it out, if you could give us a page and a line number.
absolutely. Page 2, lines
25.
25 and 26, and that's something that's carried over from the original bill. What exactly that's about, I don't know. And that actually brings me to one of the issues that one of the things that's not addressed in this bill is the right of trans students to, you know, participate in school activities and to be allowed to go to school in peace, which has been, I guess, abrogated by various actions taken. Also, there's another omission there. There's nothing about children who are and parents who are different in other ways. So there's nothing there to protect LGBT children, you know, lesbian or gay children, lesbian or gay parents, also even people merely of a different racial category or different in some other ways. So there's no protections at all for the rights of those parents or those families enumerated in this bill. They do talk about sex education, although children, you know, children are going to learn about sex regardless of whether or not you take them out of sex education. There's there's also language there about immunizations. You have the right to opt out of immunizations, which I guess you already have, but there's nothing in there about the right of parents who support immunizations to not have their children exposed to unvaccinated children in the classroom, where nothing there to tell them how to protect children from transmissible diseases. In fact, there's other. Although on the other hand, it doesn't address the issue of mask policies either, but that's other missions. I just think this bill is unnecessary. I certainly will look forward to see when we have the House session day after your May 4th executive session, what comes out of it. But I see very little or no chance that a bipartisan compromise can be reached that I personally can support. So I think the whole aim of the bill, it's well intentioned, but I just think the whole aim of the bill is like not head in a direction that can get the type of consensus that we should have before passing a bill like this. So I'm inclined to say just find this inexpedient to legislate and move on. And I'm sure this bill will come back in another form at a future session. But
will you take questions?
Oh, sure. Yes.
3 minutes, and you're well over it. Any questions, Representative Raymond?
Thank you, Mr. Chairman, and thank you, Representative Horgan. I just have one question. Would it surprise you to know that almost everything in this bill, with the exception of the medical records, is already in state law? And there's a technical advisory on the Department of Ed's website from August of 2022 that lists literally almost everything, including the RSA that it came from.
Oh, not at all. No. So that's, which I'll also mention this bill is in not really the chapter of the RSAs, but I expect to see it. I guess it's one about, child safety law, but it's not in the RSA about schools, which is also another flaw in it, that it mostly only applies. You can only enforce these laws if the school is part of a school district. So that leaves out private schools, obviously, also charter public schools, public academies, and also the various institutions that are subsidized by the EFA voucher program. So yes, but I would certainly believe I hadn't thought of that advisory. I think I did see it 3 years ago. But yes, I would believe all of that. And of course, I've had a bunch of other things I would also believe. So thank you. Thank you for the question.
Representative Love.
Thank you, Mr. Chairman. Thank you for taking my question. As I read the New Hampshire State Constitution and the U.S. Constitution, I haven't seen any carve-outs or anything that says except for LGBTQ. We all have the same rights. Am I missing something?
I don't know, but I mean, what's the state and the U.S. Constitution, although I'm having about my doubts about what the U.S. Constitution, which parts of it are actually being enforced or which ones have been overturned by executive order. I shouldn't have said that. But anyway, yes, but I think respect for all people is something that's always been a principle of both the U.S. and state constitutions. And of course, bringing the LGBT community, that's a relatively recent development, but it's in line with how the American how we view the rights of people here in the United States of America over the centuries. So, and there's always been LGBTQ people in the United States anyway. But so thanks.
Okay, thank you for your testimony. And I'm going to address the audience. We have a stack of cards. Most of you have appropriately put down time to speak 3 minutes. I can't speak for others, but I'm of an age where after 3 minutes I start nodding off. So the first 3 minutes are very important. After that, but also numbers of you have taken time off from work or whatever to be here. And if somebody goes way over 3 minutes and then somebody else and then somebody else, it may be 5 o'clock when we close and you haven't been heard and you've wasted a day off from work. So I'm going to hold you to the 3-minute rule. And at 1 minute, I'm going to go something like this, and at 2, something like this. And when we get to about 2:50, I'm going to say, wrap it up, please. And I'll give you a little time to finish your sentence and so on. But I'm going to hold everybody to that roughly 3-minute rule. With that, the chair recognizes Mr. David Trumbull from Ware.
Oh, thank you.
And the hardest thing to testify here is you have mastered it. Turn the light on, turn the mic on. Thank you.
Thank you, Mr. Chairman and committee members. David Trumbull from Ware. I oppose this bill for 2 reasons. I agree with the representative that everything in the bill is pretty much in state law, but there's 2 key additions to the bill that are not in state law. The first is that it adopts the strict scrutiny test, and it creates basically an absolute right for parents in relation to their children in schools, and that's counter to the New Hampshire Supreme Court's latest ruling on this case. In the case of Doe v. Manchester School District that was just decided in August of 2024, it involved whether or not a school should be forced to reveal a student's LGBTQ status to the parents. The court said they were basing their decision solely on the New Hampshire Constitution. They said parents do have a fundamental right to raise their children, but when applied to the school setting, this right is, quote, not an unqualified right. They said that the Manchester policy did not infringe upon the parents' rights. The parents had other numerous self-help remedies, and that any interference, quote, with parental rights that may result was not of a constitutional dimension. The court concluded it follows that strict scrutiny review is inappropriate, and the trial court did not err by applying the rational basis test. That's lawyer talk. But what that means is that on page 2, lines 2 and 3, where the bill would require the compelling state interest test, require that anything be narrowly tailored in no less restrictive means, that's the strict scrutiny test. The Supreme Court heard a case on this very bill and say that's the inappropriate test. Instead, you should use the rational basis test and allow the schools to do their job. So it's a good bill, but it goes too far. It creates basically an absolute parental right. The second problem is the vague standards about what's included and what's not included. I'm looking at the new amended version, page 3, lines 13 to 17. It says that parental rights are more comprehensive than those listed in this section, unless such rights have been legally waived or terminated. That part. And page 2, lines 5 to 9, where it says including but not limited to. So the question is, does the absence of specific mention of the rights of LGBTQ students, does that mean that that's not included in this list, or does it mean that it's to be included in the unspecified rights? We've had this bill discussed and debated numerous times with dozens of hours of testimony. It should be made clear, because if you're a school or a teacher, you don't know whether or not you can or can't listen to a child who tells you, look, I'm gay, my mom understands, my dad doesn't understand, what should I do about it? How do I negotiate this at home? What is the school's obligation? What is the parent's right there? There's a chilling effect on schools. You might say, well, what's the difference? The difference is that for LGBTQ children, home is not always a safe place. This is from the Trevor Project. 14% of LGBTQ youth report having slept away from the parents because they were kicked out, 40% just because they were LGBTQ. And we know that having a trusted adult, just one trusted adult, reduces suicide attempts by LGBTQ, which are very high incidents, by 40%. And the Department of Education in the state had a one trusted adult program. This bill would run counter to it. So thank you. I guess what I'm saying is I agree with the concept of parental rights. This bill goes too far. It creates two new rights. One, it makes it an absolute right by adopting strict scrutiny. And two, it says, here's the list of rights, and then there's a bunch of other things, but doesn't say what they are.
Thank you very much. Would you take questions? Okay, any questions? Representative Love, and sir, you'll have to turn your mic back on.
Thank you, Mr. Chair. Thank you for taking my question. Because the incidence of suicide is so high in LGBTQ children or adolescents, don't you think the parents, the most important people in their lives, should know?
Thank you for the question, Representative Love. I do believe that parents is where it starts. And what I did point out and what's come back to is that 14%, 1 in 7 LGBTQ youth were kicked out of their homes, and largely just because they are LGBTQ. Now, for most parents, they understand their children, they're supportive of them, they want to love them and do anything they can for them. But there are some homes where that's not the case. And the only place that that child can talk to somebody is maybe their coach, maybe a boss, or it might be somebody at the school. And this bill, by creating an absolute right, 100% of the rights in this equation, you got the child, the school, and the parent. And this bill says the parent gets 100% of the rights. The other two parties basically have no rights. That's out of balance with what would be healthy in every single case. And I say that also too, I'm a parent.
Further?
I had 2 children, so I'm not against parents. I'm just saying it's not always, it shouldn't be at that ratio. That's
Seeing
all.
nothing else, thank you for your testimony.
You're welcome.
The chair
Thank you.
recognizes Sam Hawkins from NAMI, and you have handouts.
Good afternoon, Chairman Pearson, members of the committee. For the record, my name is Sam Hawkins. I'm here today representing NAMI New Hampshire. I want to be clear from the outset that NAMI New Hampshire is not taking a position on this bill, and as an organization, we do not serve just individuals, but also families. So as such, we do believe in the fundamental importance of that parent-child relationship. We do have 2 concerns with the bill, however, that I'm here today to represent. I've only had a limited amount of time as others in the audience to review the amendment, but I do think these concerns are applicable to both. To begin, it is our understanding under current law that unless otherwise prohibited by law, parents do have access to review all medical records relating to their child. In regards to the amendment, I do have some concerns that it seems that that provision of unless otherwise prohibited by law is not in there. Further, this policy as it is provided in House Bill 10, we feel does not fully consider all situations where it may potentially be necessary to withhold access to records. Specifically, we feel strongly there should be some mechanism for withholding records if the provider has a reasonable belief that such disclosure will result in abuse or neglect. There have been similar bills here in New Hampshire that provide parental access to records. I know one came before this committee, and that bill saw it necessary to include a similar standard to that by which a provider can deny access. If the committee is going to add that in, we do, however, feel strongly that the standard used should align with the standards in the state's Child Protection Act. Moving on to our second concern, I would again first like to emphasize that the family relationship is the most impactful in a child's life. but we also know that that is not the only relationship in a child's life, and it takes a full community of support to build a healthy, thriving adult. As such, we do have a concern relating to the language of, quote, attempts to encourage or coerce. While there's no situation where we believe it is appropriate for an educator to coerce a student to withhold info, we do believe that the way this language is interpreted by students or by educators may have a negative impact on that educator-student relationship. We know that some children may approach other community members, including educators, with their questions or feelings before opening up to their parents. This is not because that relationship is less important than the parent relationship, or it is not because that relationship is more important than the parent relationship, but because that relationship is actually a lower stakes opportunity. Essentially, we have some concerns that that language may be broadly interpreted by educators or students to mean they can't discuss anything without a parent knowing about it. I apologize, I bumped the button. In closing, this may result in teachers not being there for students when they need them, or students not being willing to speak to teachers when they need to talk to someone. And lastly, these conversations are important stepping stones to actually building a child's confidence so that they will actually go to their parents rather than going on struggling in silence. So with all that in mind, we ask that if the committee advance any bill does this, there should be consideration of those concerns, and I thank you for your time.
Thank you so much. Would you take questions?
Absolutely.
Don't see any questions.
Thank you.
Thank you. Chair recognizes Heather Robitaille.
Good afternoon. Thank you, Mr. Chair and committee. My name is Heather Robitaille, and I'm from Merrimack, and I'm here today as a proud parent of a public school student to voice my opposition to House Bill 10. I did read over some of the amendments that were just brought forth, but my biggest concern surrounding this bill is the negative impact that it will have on public school educators and the education New Hampshire children receive in our public schools. I can speak that in Merrimack, we already have policies in place from the school board and district regarding reconsideration of materials, as well as parents' ability to opt their children out of any curriculum portions that they deem objectionable. This bill is specifically targeting public schools and their educators, giving parents procedures to object to instruction materials based on, as noted in line 26C, beliefs regarding morality, sex, and religion, or the belief that such materials are harmful. Parents claiming violations of these provisions in these bills may bring forth an action for injunctive relief and damages against the district and take action against the teacher, including losing their certification. Many of New Hampshire school districts are already struggling to find qualified teachers to fill positions, and the provisions and penalties of this bill will increase this problem, resulting in a critical shortage of educators in New Hampshire's public schools. One of our amazing paraprofessionals in a recent school budget committee meeting stated, "I don't make a living, I make a difference," and our teachers do. Threatening our public school educators with a criminal record, as it was initially written, although amended, it's unclear whether or not they would still have a Class A misdemeanor as a result of violating these provisions. If they are unable to teach and earn an income, it's going to have disastrous consequences. If this passes, educators will undoubtedly limit the diversity and inclusivity of their instructional materials for fear of parental reprisal. Every parent has the right and responsibility to discuss their personal, religious, and moral beliefs with their children. They do not and should not have the right to censor instructional materials meant for all children simply because one family or a few individuals disagree or find it objectionable. Our children should be taught to be critical thinkers who are able to positively contribute in their diverse local and global communities. This bill will place an undue burden and strain on public school staff, resulting in an increased workload as right-to-know requests and copying of materials increase. The district and ultimately our taxpayers will have to shoulder the increased expenses associated with these requests.
Finish it up, please.
Thank you. Our children are our future and our leaders, and they have a right to receive a well-rounded education. I stand with our teachers and our students and ask you to please oppose this bill. Thank you.
Chair recognizes Deborah Howes. Chair recognizes Kathy Stratton from the New Hampshire Medical Society. Oh,
Getting untangled.
you are Deborah House.
Good afternoon, Chairman Pearson and members of the House Children and Family Law Committee. My name is Deborah Howes, and I am president of the American Federation of Teachers, New Hampshire. I'm here on behalf of our 3,500 members across the state who mostly work in pre-K through 12 public education as well as at public universities. To speak about House Bill 10. We were opposed to the bill as originally introduced, and while I will talk about the amendment in a moment, one of our big oppositions to the bill was that it would class violations of the bill as a misdemeanor, leaving educators and school staff with a possible criminal record and fine for violating something that had some pretty vague wording in it where you could violate a right that was not even enumerated in the bill. That would be a big problem. Now, we find this amendment is an improvement. It did take out that language, so we are pleased to see that. It also took out the attempt to coerce language, which was very confusing. We do still have some concerns, and some of them have also already been mentioned. On page 2, lines 5 through 11, someone already testified about this earlier. We do agree that the parents obviously have the right to direct the education and care of their children and direct the upbringing and moral and religious training of their children, but that is not an absolute and unqualified right in all circumstances. When you juxtapose that against sending a child to public school, if every single parent insisted they had the right to direct what goes on in the classroom, and parents have different ideas of what's supposed to be going on in that classroom, how do you teach? What do you teach? When you send a child to public school, how we decide what to teach is the job of the local school board. They adopt the curriculum. So if we could somehow maybe redirect this to have parents either exercise the opt-out provision if there is something they seriously object to, and or engage in the school board's curriculum adoption procedure and policy and materials adoption procedure and policy, because school boards are elected representatives of their local community, and they do have committees that work on this and welcome parent engagement. That's how we decide what gets taught in the classroom. This piece of the bill could very easily lead to individual parents trying to micromanage what all children get to learn in the classroom, and that's not right. I don't think that's what you're trying to do. We also have similar concerns to the line 26 on page C, 26 and 27 about instructional materials. Certainly, if you want to review instructional materials, I understand.
Time to wrap it up.
That also repeated request for review every single piece of paper, every single worksheet, every single example used in a classroom has a chilling effect on what teachers provide to students. And
Okay, we've finished now. Boy, I know. Would you take questions? Representative Love.
Thank you, Mr. Chair, and thank you for taking my question. Would you believe that on primary day, I had a constituent come up to me and a member of our town council and told us that his 8-year-old daughter was coerced or spoken to by a teacher's aide and told that if you don't like being a girl, we have pills that'll make you a boy. Do you believe nothing's been done to that? There's been no disciplinary action taken against that teacher's aide.
I cannot comment on that because I do not know the whole story, and I'm not sure that you know the whole story either. I'm sorry to say, but you're not in the investigatory process in that school, are you? Or in the district or with the Department of Ed? And neither am I.
I did turn it over to the Department of Education.
So they are following the process, and they will certainly look into it. We have certainly heard from many places where they have looked into complaints.
Representative Petrino.
Thank you, Mr. Chairman, and thank you for taking my question. Would you say that there are procedures when a teacher violates their professional conduct, that there are procedures in place to address those things accordingly that would be separate from this legislation?
There are procedures. There are, depending upon what the concern is, they are either employment procedures or they are, code of conduct procedures, and the investigation either starts at the local level or starts at the state level. But there's a whole series of procedures that are followed. And yes, investigations do indeed happen frequently. We do hear about them all the time through our union. Yes.
Thank you. Now the chair recognizes Kathy Stratton from the New Hampshire Medical Society, armed with 20 copies of handouts. Well, we would have looked at it and not you, so being a good teacher, you didn't. I remember the days when handouts, we always used to pick them up and sniff them because of, remember those dittos, days of the dittos?
Amazing how powerful those memories are.
The sense of smell. Why don't you just hold on for one little second before the clock starts up here, okay?
Good afternoon, Chairman and members of the committee. My name is Kathy Stratton, and I'm the New Hampshire Medical Society CEO speaking for the Society in opposition of Health Bill 10. On behalf of the Society, I'd like to begin by reiterating that we fully recognize and value the important role that parents, guardians, and advocates play in the care and treatment of minors. We have serious concerns, however, about how the proposed House bill would interfere with the fundamental physician-patient relationship and the punitive consequences it would impose on medical professionals who are working to treat minors. Speaking specifically to Section 3 that addresses healthcare services, the Society's position is based on the premise that healthcare providers must have the autonomy to make medical decisions that are in the best interest of their patients. The provisions within section page 5, line number 14, that begins the parental consent for healthcare services, introduces specific barriers to this autonomy. Specifically, the first point of the bill states, except as otherwise provided by law or a court order, a healthcare practitioner or an individual employed by such healthcare practitioner may not provide or solicit or arrange to provide healthcare services or prescribe medicinal drugs to a minor without first obtaining written parental consent. This provision would require parental consent before a physician could even schedule an appointment for a minor. Such a law would create delays in treatment and potentially dissuade minors from seeking care, particularly those who may fear for their safety or well-being. As we continue to combat stigma surrounding mental health care and substance use treatment, it's critical to recognize that additional barriers this law would introduce could discourage these vulnerable individuals from seeking care, resulting in life-threatening consequences. There are situations where the protection of a minor's confidentiality is paramount to their health and well-being. Under the proposed bill, healthcare providers would be forced to prioritize navigating legal and custodial complexities over providing the necessary care to the child. This creates a direct conflict with medical ethics and prioritizes patient safety and confidentiality, especially for minors in vulnerable situations. The Society's position in opposition of Health Bill 10 aligns with our mission to promote patient and public health. If passed, this bill would create undue barriers to care, undermine the physician-patient relationship, and impose penalties on physicians and healthcare professionals who are dedicated to protecting and healing children We believe that House Bill 10 would have devastating consequences for minors in need of medical and mental health services. Therefore, we respectfully urge you to vote inexpedient to legislate on House Bill 10. Thank you for your time and consideration of our testimony.
Representative Raymond.
Thank you, Chairman Pearson, and thank you, Ms. Stratton, for taking my question. So I'm trying to apply this section that you're talking about on page 5 to real life, because I'm a parent of teenagers. And so I'm going to give you a situation that happened this week and tell me if this bill would change how the process worked. So my 14-year-old is having her wisdom teeth out on Friday, and we have prescription. She's supposed to have a prescription mouthwash that she's supposed to use prior to the surgery and then for several days after the surgery. But it didn't get called in to the pharmacy with the antibiotics. So I called them from my phone this morning and said, hey, I didn't get the prescription for the mouthwash. I remember us talking about it. I've signed nothing. Can you call it in to Hannaford and I'll pick it up on my way home from the State House this afternoon? And they said, sure, no problem. We'll call it in because we know that your daughter needs this. And so I'm going to go pick that up tonight and then she'll start it Thursday. If this is passed, will I have to now drive to the oral surgeon's office and sign a permission slip for them to write that prescription for the mouthwash that we knew was coming because I have older children who've already had this process?
You know, I'm not an attorney, so it's a great question because the bill does state written parental consent, and I'm not sure how that would apply. You know, whether your initial statement of consent for the surgery would have applied. I just don't know. We would have to consult with attorneys on that. But it does create a barrier, and you know, I think that that's a problem in providing treatment.
Thank you for your testimony. The chair recognizes Anne Marie Banfield for 3 minutes.
Good afternoon. Anne Marie Banfield, parental rights advocate focused on excellence in education. I do come in support of this bill. However, there is a glaring omission in it, and I want to go through that. The parental rights bill should be free of a laundry list of what Democrats and Republicans want. It should be focused on parents' authentic rights to care for their children. A student's personal information is now a commodity by ed tech vendors. PowerSchool released a statement a short time ago notifying everyone about a data breach. Personal information on students, including their social security number, mental health information, and other sensitive data points were captured by hackers. But what most people don't know is that PowerSchool is currently being sued for sharing and selling student data. From the lawsuit, it says PowerSchool, without effective consent, collects, stores, analyzes, and shares student-sensitive data, which it acquires through its educational technology products that it sells to schools and to school districts. The information PowerSchool takes from students is virtually unlimited. It's 87 pages. I've read most of it. I would suggest you do. I will send you the link. EdTech vendors are collecting very specific data and claim that they own the intellectual property of these students. That means that they are also storing emails and that the child sends and receives. So everybody in the world can access the student information, but for some reason, parents can't. Isn't that interesting? If you have children using a school-issued Chromebook where they access all of the ed technology, good luck. This is how they also develop a psychological profile on children. There was an article in the Wall Street Journal several years ago from a medical professional in New Hampshire, and it's called, "Have You Seen Junior's Psych Profile?" And that is because of the vendors that are collecting all of this behavior and mental health information. Why are we allowing a school or institution to claim ownership of my child's intellectual property? Can you even describe what that means? Data is gold to data brokers, and on the web, they're the technology for the technology companies. None that should be shared, sold, or even accessed without parental consent. In addition to what was brought up, data sharing used to be illegal 10 years ago. You couldn't do this, but it's legal now because there's a loophole in student privacy law. So this kind of legislation is good going forward. That's why it is needed. Every Student Succeeds Act requires mental health professionals in the school to obtain consent from parents on mental health services or assessments. So if that's a chilling effect, guess what? People in our school are breaking federal law because they should be doing it already. So if a if a child walks up to a teacher and begins chatting about their mental health information, that teacher should be getting parental consent. It's in federal law.
Wrap it up, please.
And anyone can file a 91A. So it can be a parent, it can be a non-parent. Also, the APA Code of Ethics for psychologists.
Okay, you're way over time. Okay, thank you. The chair recognizes Representative David Luno.
Thank you very much, Mr. Chair, members of the committee. For the record, my name is Dave Luno, representing the people of Hopkinton and Bow, which is Merrimack County District 9. But as I also like to say, Granite Staters from every corner of our wonderful state, because what we've got before us today is a bill that affects all of us, and we all have statewide responsibilities. So I just want to get to one piece, and just to lay the groundwork a little bit. One of the very last things the last legislature did before breaking in December was to approve changes to what are called the Ed 306 rules. And I spent 12 years on a school board, and I'd never heard of the Ed 306 rules. But these are the rules that set the minimum academic standards for all of our public schools across the state. And so one of the things that really became obvious during this work is that the rules that had been in place for the last decade were replaced with rules that have been around, in some cases, more than 20 years. So what we're looking at now as minimum state standards for schools, are really low standards and in some case no standards. Standards for superintendents were eliminated. Standards for school business officers were eliminated. And standards for curriculum and instruction were changed and watered down so heavily, they don't even resemble what is being taught in schools today. So it's an unfortunate hallmark of the New Hampshire Department of Education, the commissioner, and the state board. So I'm specifically looking at page 4, lines 36 and 37. Where it says in the Bill of Rights that you have the right and expectation that academic curriculum taught in your child's school align with New Hampshire and federal law. Well, we're really lucky because New Hampshire public schools are some of the best in the country, and our students perform among the best in the country. And it's because of that local control, local curriculum, and high expectations that our voters in every district in the state have. And why do we know that to be the case? Because every year they open up their pocketbooks and fund their school districts, because the state of New Hampshire doesn't fund them. Voters have high expectations for our schools and high expectations for our students. I'm concerned that these two lines will change that. So appreciate your consideration.
Any questions for Representative Luno? Representative Raymond.
Thank you, Mr. Chairman, and thank you, Representative Luno. So I just want to make sure I understand your testimony. Are you concerned that this line C on line 36 will override local control of the standards and end up in a situation where the state is now determining it instead of the local school boards?
I am concerned about that, and especially when nearly every school in the state is is utilizing academic curriculum that is up to date, effective, and puts our students in a position where they're competitive, not just nationally but globally. And this is important. This is why our students do so well. I'm just concerned that that having the expectation that the curriculum taught in your child's schools aligns with these low standards adopted recently by the state are just going to hurt our schools and hurt our kids. Great. Thank you,
Representative. Chair recognizes, I believe this to be Zoe Hill. And please turn on your mic. Now, that's the hard part. The rest is easy here.
Good afternoon, representatives. My name is Zoe Hill. I am a resident of Lebanon, and I am here to testify in opposition to HB 10. If passed, this bill will take away safe spaces for children outside the home. Sadly, some children's homes are not safe. And that is why it is so important for these spaces to exist outside the home, like in schools and in hospitals. And when children do not have people to talk to about their mental health and their feelings and anything that they are facing, their mental health can deteriorate, even leading to the point of self-harm and ending their own lives. A vote inexpedient to legislate is a vote for children's mental health. Thank you.
And thank you. Representative Gregg.
Thank you, Mr. Chairman.
I didn't ask if you would take a question. Would you take a question?
I will take a question.
Representative Gregg.
And thank you, Zoe. Would you believe that we are very honored you came to speak with us? And thank you for being so brave.
Thank you.
You were given 3 minutes. You took a minute and 20 seconds. Next time you get back, come back here. You got a minute and 40 extra. I owe you.
All right.
All right. Chair recognizes Sarah Terrell.
Thank you for leaving the mic on for me, Zoe. Good afternoon, committee members. Thank you for taking the time to hear public comments on this bill today. My name is Sarah Terrell. I'm a lifelong resident of New Hampshire and the proud parent of two wonderful children. My son is 18 and thriving in his first year of college. My daughter is 16 and a dedicated high school sophomore. I'm here today because I have serious concerns about this so-called Parental Bill of Rights. At its core, this bill assumes that parents and schools are at odds, that they require government micromanagement to work together effectively. But that simply isn't true. Parents and educators already collaborate every day to support children's learning and well-being. This bill does not strengthen those relationships, it undermines them. More specifically, I'm deeply troubled by the provisions that could force schools to disclose a student's LGBTQ identity before they are ready. When my daughter came out to me, it was in a moment of immense trust and vulnerability. I could see the anxiety on her face. Even though she had no reason to doubt our love, she was still afraid of how her father and I might react. That moment belonged to her, to our family. If someone at her school had taken that decision away from her, I would have been devastated. No one, especially a child, should be forced to reveal something so personal before they are ready. This bill claims to protect parental rights, but at what cost? It disregards the rights and dignity of the very children it claims to serve. Not all students are lucky enough to have supportive families. For some, being outed could mean rejection, homelessness, or even danger. The government should not be in the business of putting vulnerable children at risk. I urge you to listen to the voices of parents, teachers, and students who know firsthand that collaboration, not government overreach, is what truly benefits children. This bill is unnecessary, harmful, and dangerous. Please vote ITL on HB 10. Thank you. I will take questions if anybody has any.
Questions? And I owe you a minute and 10. This is getting to be a trend.
I'm going to take you up on that.
Oh,
at some
good.
point.
You write that down somewhere.
Thank you.
Chair recognizes Betsy Harrington.
Hi, thank you for allowing me the time. My name is Betsy Harrington from Deering.
I'm the parent that you guys are talking about. I'm the one with kids in high school who wants the right to know what's going on. I'm the one who looks at their curriculum and decides what they can and don't do. And so just this year, I have one teacher that really likes to cross my boundaries on the regular. And I try to respect her vision and my vision of what kind of education my child's receiving. So I respectfully told her this year, there's something called ratedbooks.org. It's an organization that rates books for age inappropriateness. And so she was sort of acting like she couldn't get along with me because I wasn't going to approve books that she was giving the kids. And I said, oh, just go to ratedbooks.org. And if it's rated 4 or 5, it's a no. And just respectfully, it's a no. I appreciate you checking. And that's it. I haven't had to talk to her again about it because I just set a boundary and that's it. I want to be able to set boundaries. I want to be able to see what the curriculum is. My kids are at the top of their classes, and it's for a reason. It's because I'm a good parent and I'm in tune with what's happening. I also worked for DCYF. I worked at the prison for 10 years as a sex offender counselor for 5 of those. And I feel like having been a therapist, a mom, all these roles, that I can say that this bill is necessary. I support it and it's necessary. Good parents need to have a right to be good parents, and you're taking away from them. We already have a way of dealing with bad parents. I worked at DCYF and I know what it was like, and we dealt with bad parents. People called us, schools called us, and we already have something in place. We need all of these amendments here, and because I read the whole thing again, it's a little different than it was to start with, but we still need all of these. I'm pretty support. I could see that changing a word from a to the might help, but otherwise, I'm overall really supportive of this bill. I'm the parent you're talking about, and please consider my thoughts of how I might raise my kids. Thank you.
Representative Petrino.
Thank you, Mr. Chairman, and thank you for sharing your story. I appreciate that. So I'm just curious as to whether or not you were denied the opportunity to review the materials in question. And if you were denied the opportunity to have your child opt out of those experiences. And lastly, if that's the case, did you talk to the administration and say, hey, look, my parental rights have been violated here. I don't want my kid to have access to these materials.
So when I went to the school to talk about the books that I felt were inappropriate, the school's response was, and we had no challenge policy at that time. It's since changed based on my complaints. But at the time, there was no way for me to challenge a book. I could only go to the school board and say, hey, I have issues with these books being available. They banned my children. This was 3 years ago. My oldest is about to graduate. They banned my children from all libraries that day, and my kids have never used school libraries ever. They've never been allowed.
Thank you. You may be absolutely right. My understanding is that the parental right to opt children out of certain school experiences already exists. And if that's the case, in your instance, then I would suggest that your rights were in fact violated and the school district had to address your concerns. So that's where I'm a little bit confused, because my understanding is the parental right to opt their child out of something they believe to be questionable already exists. The parental right to have children have access to certain materials at school already exists. And if that was not your experience, then I would suggest that your rights were violated and the school district was in error.
I feel like my rights have been violated. Another example is like the survey that they give to all the students every 2 years. I opted out of that. They still gave that to my kids. Now, my kids refused, and they still tried and pushed and tried to give that to my kids. And when the girlfriend of one of my kids came home that day to our house that day for dinner, I said, how was it? And she said, it was traumatizing and triggering. So I was happy my kids stood their ground and refused, but they still tried to give that to my kids. And they still try to give my kids age inappropriate stuff. I just keep setting boundaries. Do they show me all the curriculum? No, I don't get to see everything, but I try to see whatever they will let me see. I do think that this is necessary.
Yes, follow up, please.
Thank you, Mr. Chairman. And just one last follow up on that. So if the parental rights that we spoke of already exist, such as the right to opt out of certain materials at school, and your rights were violated, as we've acknowledged, then how would restating those rights again in this legislation take care of the problem that you experienced? Because in either instance, your rights were violated. So
This
how
is
would
going
this
to prevent
legislation?
secrets. To me, and for me, when I look at this whole thing, it's going to prevent secrets. And as a therapist, I've been a therapist, I'm not one now. I really think that that's dangerous. I think the parent-child relationship is more important than any other relationship, and that's the one we need to prioritize.
Representative Nelson.
Thank you, Mr. Chairman, and thank you for taking my question. I want to preface this by saying I'm an assertive person. You're an assertive person advocating on behalf of your children. I try to do the same. My question is, do you feel like there are many parents who are not as assertive as we are, or who are comfortable being as assertive as we are when it comes to school matters?
Sure, some are not as comfortable as me.
Follow up, please. Thank you, Mr. Chairman, and thanks for taking my follow-up. Do you feel like this framework of an actual parental bill of rights might be very helpful for parents who are not as confident or assertive as we may be?
Absolutely. People reach out to me all the time and ask me for help because they know that I'm the person who would show up and speak for them here.
Thank you.
Welcome. Thank you for coming.
Thank you.
Chair recognizes, I can't quite read it all, but it's James from Atkinson. If you were James from Atkinson, come on down. Tell me your last name, please.
I went to your service last week, Pastor.
I know you did. Oh, there it is. It was on my glasses. That's why I couldn't read it. Sorry.
So I'm speaking on behalf of supporting the bill and all the sponsors who support it. I started off about 20 years ago as a father's rights advocate. That's when I probably met Deb DeSimone. And that expanded when I started to see the other side of the coin. I saw moms and I saw grandparents affected greatly by family law. And grandparents especially are important to me, especially as I age myself. And now we've come to a different topic about the same targeted people, which is kind of sad in a way. But I definitely support the intent of the bill. I support your changes that you need to be made, given everyone who's spoken before me. And I think you're doing the right thing by instituting it as a law, because we've come to that place where we have to decide who gets the decision of the child, who's going to be deciding for them. When I was advocating for children, I saw clearly that a lot of them were basically ruled by their parents, and whether or not we liked what the parents did, other than violence, we have to support them. But it's come to a point now where it's getting a little bit out of hand, and I'm going into bathrooms that don't say the gender anymore. So I'm a little worried myself. And so I speak on behalf of this, Mr. Chairman. I'm open to any questions, and I'm hoping I'm short enough that I'll get my excess time for the next bill.
I keep a log. Any questions for the gentleman? Seeing none?
Thank you.
You got a little over a minute in the bank.
Thank you.
Chair recognizes Karen Leot Hill. Do I have that right?
Yes. Karen Leo Hill.
I'm sorry? Lee.
The T is a little sneaky because it's silent, so it's Karen Leo Hill.
Okay. Did you have a relative in the house at one point with that
I did not, but I'm a 20-year city councilor and the former mayor of Lebanon, and so I have testified in this body.
I wasn't
on a number of
asking your
occasions.
experience. I just knew somebody.
Oh.
Okay.
Oh, okay. Well, thank you. Good afternoon, representatives. Mr. Chairman, thank you very much for allowing me to testify before you today. I am here as the executive counselor representing District 2, 81 cities and towns in Western New Hampshire, including the capital area. I understand that the intention of this bill, it seems, is to compile and assemble all of the references to parental rights into one place to make it easier for parents to understand their rights. And I can understand that that is a good intention. I do believe that there are unintended consequences in this bill that make it harmful. I believe that some of the language is vague, that would make it difficult to enforce. And I believe that based on all of these reasons, including the testimony of others offered before me today, I ask that you consider voting inexpedient to legislate on this bill. With regard to vagueness, one is that's been discussed earlier is the definition of parent and whether that could introduce, whether the parent is specifically the parent of a minor child in a school, or whether this could introduce potential challenges or interference by parents who happen to have minor children but are not involved in a school. There's some vagueness there that could be challenging to enforce. There's also the word morality, which is referenced and does not have an attendant definition. The word sex is also referenced, and I can point you to the place. It's on page 3, line 27. This is where the word morality and the word sex appear. A few lines above it, the word discipline appears on page 3, line 23. The word discipline is also not defined in this statute. They mentioned the word morality is not defined. The word sex is also not defined. There's a lot of discussions about what sex is, and I think if it appears, it should probably be defined somewhere. Otherwise, it's potentially ambiguous and could lead to questions about enforcement. We've heard from the Medical Society about the barrier to care that this bill could potentially present. It certainly is, I think, an unintended consequence on those bringing forth the bill. I don't believe that they intend to create a barrier to patients, to minors who are seeking medical attention. Nevertheless, we did hear testimony from trusted providers that this could create an unintentional barrier to care. We've also heard testimony that it could have a chilling effect on safe spaces and the ability of teachers to teach children in their custody. As someone who experienced violence in the home as a child, I'm here to testify firsthand about the importance of safe spaces. For all of these reasons and more, I would encourage you to vote inexpedient to legislate on this bill. If it is worth doing, it's worth doing right, and I would suggest that this bill could use some more work before bringing it to a vote. Thank you so much.
Councillor, will you take questions?
I will. Thank you very much.
Thank you. Chair recognizes Betty Gay. Frequent flyers, you know, you get to know your people.
We don't get points. Thank you very much for allowing me to give my parental response. I think that this bill needs some more wording adjustments, which can be done with by continuing it. But I think what our previous speaker just pointed out, it would be really good to have parental rights in one place, because right now it's covered in many different places, in many different bills. So considering all the inputs that people have come and been concerned about, some of which are unfounded because we already have laws, or we're considering laws to fine-tune exactly what a parent's rights are and how to protect children when those parents should be reported. We're all mandated reporters. So I'm thinking that if a child at school tells somebody that things are really going badly at home, we're not talking about parental rights there. We're talking about mandated reporting. So I think it's really good to continue to work on this bill, to refine the wording so that it's clear, so that not a parent could go to another school system and say, oh, I want all your records. We obviously do go and use data from many different school systems to put out a report.
our schools are having some real problems. I was shocked as a resident of Salem, which is a pretty big town, not poor, and the reports on the children's achievements, educational achievements, they're about 50%. I don't know about you, but that sounds terrible to me. So something is the matter. I know we've adjusted how to teach reading, which is a basic, if you can't read well, you're not going to do well in anything except PE. Even written tests, not there. So obviously we're trying to work on issues. I think parental rights have come under attack and need to be written down exactly what is okay and what a parent can expect, because nobody's talking about the experiences that they've had that were just crazy, that they didn't feel, the school personnel didn't feel like telling the parent something that we would think was appropriate. So I trust that y'all can fine tune this so it really, really will be a valuable tool. Thank you.
Thank you very much. You have 6 seconds in the bank.
I think you've already given them to me.
Yeah.
Before we go on to the next person, these were handouts that I don't see match a pink card, so they may have been dropped off. So why don't I pass them around? And if I overdid or underdid, you can kind of swap. And I was going to call Kevin. Chair recognizes Nancy Biederman.
Hi, Nancy Biederman, New Boston. Mom of 2, teacher of 15 years with a master's degree. I am also on the Rare Disease Advisory Council for New Hampshire. I am representing myself today and not the council. As far as the medical part of this bill, I do have to tell you that as a parent with a child with a rare disease, it just about made me very upset when Dartmouth Hitchcock sent a letter when my child turned 14 and said, sorry, you as a parent have no longer access to the portal and to anything that is with her records. I will tell you that is very concerning. First of all, because most of the doctors had no idea how to deal with and understand her rare disease. And my child did not have the understanding, still in her 20s, still has a hard time understanding all the medical jargon and information, and needs an advocate and support to understand what is going on. I expressed my concern to the doctors about the fact that they were keeping possible information from me about my child. Of course, my child gave me the password and the username, and I logged on, and I was the one that was doing 90% of the communication because my child was unable to. She was that sick. So as far as a rare disease parent and any parent that has a child that has any chronic medical illness, keeping information from parents and not letting the parents communicate with the doctor can be dangerous. The parent knows the information, the child doesn't. If you were 13, 14, 15 years old, do you know your family's history? Do you know all the medical information? Do you know other concerns that the doctor should be aware of? No, you don't, because you don't care about that. You care about just being healthy and be able to get on with your day and not be in pain. As far as a teacher, I hope this bill brings back professionalism in the teaching position. I don't understand why teachers feel like they can cross the line. I was always taught that there was a line, and you don't cross it between a parent and a child. In 15 years of teaching, I had to report 2 families. In 15 years, only 2 families. The way you have people come up here talking, it's like teachers are reporting families every day. They are not. I am concerned that a New Hampshire teacher tried to get custody of a student and have them move into their house recently. That was a very scary situation. And as far as parents go, we do not give up custody of our child as soon as they cross and go into the school building. As a teacher, I don't have custody of that child. That is a parent's decision.
Wrap it up, please.
Finally, teachers are not kids' friends. Administrators should not be encouraging teachers to have relationships with their students. There should be a professional boundary. Thank you.
Thank you. Any questions for the witness? Seeing none, thank you for coming. Megan Tuttle and Brian Hawkins from NEA. Which is what? Well, it's for the record. I know what it is. Don't ask a question.
Sure.
You don't know the answer to.
For the record, it's not the National Endowment for the Arts.
Oh, darn, I had a project.
Although I'm sure that's a lovely place to work as well. So thank you, Mr. Chairman. For the record, Brian Hawkins from the National Education Association, New Hampshire. We represent K-12 educators across the state. And we're here today in opposition to the bill. I do have some testimony that was based on the original version of the bill. And so I'll try to just touch on the points I think seem to be consistent with the amendment. So first, as was stated earlier, we are obviously pleased that the criminal penalties were removed from this bill, but it still leaves, it was mentioned earlier where the line is. It still leaves some vague language in there that we're concerned so that educators can follow whatever law is passed from the legislature. House Bill 10 is stating that all parental rights are reserved, including but not limited to. So this leaves open that there are other rights or violations that could happen, which would cause the person to have violated those rights to be, it's not criminally prosecuted anymore, but there is language in there about potential discipline. Similarly, there are the two issues that were brought up in the front half of the list of rights for parents: the right to direct the upbringing and moral or religious.
Bad. I'm sorry.
I think I might have bumped the button actually, but I'll continue. I don't want to lose too many seconds here. I always run out of time, so so we're concerned that is vague. That's not grounded in any statute, is just there, and it's unclear who would define that. And so again, clarity about what we're talking about. There are morals discussed in school all the time, you know, and so sharing and caring about the community, things like that. So what are we talking about when we're talking about, specifically because it says the right to direct that? And I think some previous speakers raised some concerns about, you know, how granular are we talking about there? I've got to make sure that some of the other concerns that I have listed here are still consistent with the amendment, but as I mentioned earlier, there is a reference there about the possibility of disciplinary action being referenced. And so that's a little unclear about who are we talking about. Are we talking about the school? Are we talking about the DOE? This is unclear. And I'll close by saying that, you know, I think someone mentioned earlier that parents and educators have been working really well together in the state for a long time. And we ought to be focused on legislation that's going to help foster that relationship. And I think that this takes us in the opposite direction. The one last specific thing that I'll just mention, I would just ask that the committee take a look at on page 3, Roman 2. There's a reference in letter B to a statute that I may be wrong, but 18611 Roman 9C has to do with reviewing for the Board of Education to review HIV/AIDS curriculum, and I'm not sure if that is what was intended here. It looks like this is trying to have some protective language around law enforcement. So unless I have the wrong statute or the wrong version of the bill, you may want to take a look at that. And then we have the same concern about that NAMI raised about the encourage language, and that too is very broad and subjective. So I'll close there and happy to take any questions.
Seeing none, thank you.
Okay, thank you, Mr. Chairman.
Chair recognizes Attorney Ian Hewitt from Cornerstone. And you have handouts.
Yes, Mr. Chairman, may I distribute these now?
You may. Give them to Representative Markell.
Thank you, Mr. Chairman and members of the committee, and thank you to Speaker Packard and to Representative DeSimone for their passion for parents' rights. Ian Hewitt appearing for Cornerstone, and I've just broken the first rule of trial advocacy, which is never distribute an exhibit to the jury when you're about to speak. But I want you all to see. I normally hold to that, but I want you all to see what I am talking about in my testimony. And what I've just passed around are the main operative clauses from Senate Bill 272 in 2023, which was the Senate Parents' Bill of Rights. The language you have in front of you is taken verbatim from 272 in 2023, and this language passed the Senate. A majority of returning senators not only voted for but sponsored this language, and it lost the House in 2023 by about 5 votes, depending upon what roll call vote you look at. So it should have no problem passing the House this session. The idea of a Parents' Bill of Rights really came up because school districts across New Hampshire have adopted policies in which they explicitly say that schools will not only conceal transitioning from parents, but will affirmatively lie to parents to conceal a child's transitioning. And I can't really underscore enough how bizarre this is and how strange New Hampshire is in this area. I've closely reviewed at least a dozen school district policies on the area of gender identity in Massachusetts. And I am not aware of a single school district policy in Massachusetts, not even Boston or Cambridge, that says expressly school personnel should lie to parents to conceal transitioning like most New Hampshire school district policies say. And I think this has happened because national donors and organizations like the ACLU and GLAAD and GLSEN see New Hampshire, which is a competitive purple state, as a battleground and a laboratory, and they're therefore very invested in making sure that model policies are passed in every single one of our school districts. The result being that parents' rights are much more limited in New Hampshire today in the live free or die state than in Massachusetts. So Cornerstone is constantly exploring ways we could challenge these secret transitioning and deception policies. Theoretically, we have 3 avenues to challenge them: state constitutional rights, state statutory rights, or politically through the general court. As you've heard about today, the state constitutional avenue is foreclosed. Our state Supreme Court held effectively that parents' rights are something that the child and the parent enjoy in concert together against the state when their wishes are aligned. And parents' rights are not something under the New Hampshire Constitution that the parents have over the child against the state. So we have no more state constitutional remedy. The issue is, if the general court passed a list of enumerated parents' rights that did not address secret transitioning, that would at least foreclose all of our remaining state statutory remedies, if not all of our remaining avenues for addressing secret transitioning. So to be clear, our position is not we would like to see a perfect Parents' Bill of Rights or we don't want to see a bill. Our position is that the general court should not take a step that would put us in a worse position with respect to this critical issue and actually set us back in court relative to where we are now. So if I may, one more sentence, Mr. Chairman. For example, if the general court were to pass almost anything else on parents' rights, like creating a parents' rights commission or committee, we would have no objection to that.
I'm doing the punctuation just to see what kind of a sentence it was.
Thank you, Mr.
It's
Chairman. I
very-
believe it
fairly
was a run-on sentence, but
Yes, it
one
was.
nonetheless.
But thank you. Any questions for Attorney Hewitt? Seeing none?
Thank you.
Thank you so much. And with no more pink cards, this concludes the hearing on House Bill 10. It will be exec on March 4th, so keep those cards and letters coming. Not leave it alone.
Yes. I was just thinking this is going to be exactly the day before So, I had a flashback. Saying once protections like this in some jurisdictions.